All right, good morning, everyone. We have a final plea calendar this morning. And for everyone who is not named Newsom, Woods, or Honholt, if you don't sort your case out today, you are on our January 30th trial calendar. So it's fine if we don't resolve things now, but if we don't, then I will see you again on the 30th for the call of the trial calendar. Today, if you're on for final plea, and that's everyone except for Newsom and Woods, you have the right to withdraw your plea. I think that applies to these other two as well, but just not on that calendar. If the sentence you received is different from what your lawyer asked for on your behalf, but after today, that ability expires. So tomorrow or on the 30th of January, when it's the trial calendar time, you're free to enter a plea if you decide that's in your best interest. But whatever sentence you get as a result of the plea is where you end up. So that's the main thing that changes after today if you aren't moving forward with a plea. With that, I'm gonna call the calendar just to get announcements, figure out who's here, who's not, and who's gonna try to move forward with a plea and who's not. I'm gonna go out of order in only one way. At 3 today, we were supposed to have a suppression hearing, but Ms. Nelson told me, Ms. Wood, that your client, Mr. Woods, is actually going to be here this morning, and it's going to be a plea, not a suppression hearing this afternoon. Correct. That's your goal? Yes. Okay, great. Calendar, position 1 has already resolved by way of a plea, so position 2 is Ms. Honholt. And I think she's still in custody. Okay, so she's someone you'd be bringing here. I wasn't sure if she had gotten out, or I know she's been hard to connect with. There's been a Cherokee County situation, and then just some general not happy with the world situations when we do get her. But she's that's a different person. Okay, so Ms. Honholt, I don't think is in custody. All right.
So Ms. Hammond, I believe, is in DOC custody. I will confirm that.
Huh, okay, so she is in custody, just not Cherokee or Fulton.
Yes, sir.
All right, let's look that up, and we'll figure out what we're gonna do there, but I'll make a note, DOC. Question mark. All right, Bryant Murray. Hey, Mr. Murray, how are you? I'm all right, good morning. Your lawyer, Ms. Cabrera, I don't see yet, but she is often bouncing between a bunch of courtrooms. Have you spoken with her recently?
Yesterday I did.
That's recently, that's good. Did she say that she'd see you today?
Yes, sir.
Good, then we're gonna hold for her report. She might appear virtually. Ideally, she'll show up in person so you two can speak outside. Ms. Dilligard, is this your case? And if so, have you and Ms. Cabrera been able to exchange, here's an offer, okay, I'm gonna talk to Mr. Murray about it?
Judge, I believe ADA Nix has been working on this one, and she should be here any moment.
Okay, maybe she'll bring Ms. Cabrera with her. All right, we'll see. So Mr. Murray, I'm gonna ask you to sit tight, and we'll figure out where Ms. Cabrera is and when we're gonna engage about your case, okay? Thank you. Derek Harrison. We have a few people who are online, which is kind of okay, but if I call your name, then you need to unmute, say, wait, that's me, don't give me a bench warrant.
Mr. Harrison is in ACDC right now, and we've already resolved his case. He's going to be going to accountability court. He'll be released Saturday and going to the accountability court. He's not in custody on our case. It's a misdemeanor situation, but
Has he pled in this case?
no, it's a diversion track, so I believe the paperwork's already been done.
Okay. And you're pretty sure that whatever is holding him will stop holding him so he can start, whether it's drug
Yes.
court or BHTC?
I've talked to the people at drug court and they got confirmed that he'll be released Saturday. And we've gotten notes to him to report on Tuesday.
Okay, I've signed the order that will get him a drug court ankle monitor, so that's a good sign. Maybe they'll get to me soon, the drug court folks. Well, I guess he'll be walking in. Is he being released to drug court or he's being released?
He's being released on the other thing and then he'll be walking into drug court on Tuesday.
Okay, so that is a diversion track for Mr. Harrison. Okay. Maddie Brown.
Yes, sir.
Good morning, Ms. Brown. You also, I believe, has Ms. Cabrera as your lawyer.
Yes, sir.
So we're gonna hold for her report and figure out what you and Ms. Cabrera are planning on doing with your case, all right?
Yes, sir.
Thank you. Dantius Brown. That's why we have Ms. Cabrera on the case.
Judge, I think he's on Zoom, but I just got an email that he wants to come in person, so.
Okay.
we're just waiting on that.
He'll be here this morning.
Yes.
Okay. And Ms. Brown, remind me if you are in any way related to the other Brown.
Yes, sir. That's my son.
That's your son. Okay. He's right here. Hi, Mr. Brown. I saw, okay, I didn't know who, I mean, I saw these happy faces. You're here. Ms. Wood is here. Ms. Wood, what's happening if you know with Mr. Brown this morning?
I should just leave him after the call, calendar check.
Okay. Mr. Brown, Ms. Wood's gonna talk with you and then we'll figure out where we're going with your case. Robert Phillips.
Good morning, Judge. That's my case. Mr. Phillips is present. I just received an offer from Ms. Dilligard this morning, and I believe that we'll finish negotiating a little bit this morning and speak with my client.
Okay, you're not Scott Smith, so
I am
you,
not. I'm Beth Goldstein from Scott Smith's office.
great, Ms. Goldstein, excellent. So Mr. Phillips, you and Ms. Goldstein are gonna talk. She'll be talking with Ms. Dilligard, who's the prosecutor, and we'll see if we can resolve your case today. You heard what happens if we don't. I'll see you on the 30th, okay? Thanks. Camille Carpenter.
Good morning, Your Honor.
Hi.
Got Calloway from Mrs. Carpenter. She is present on the Zoom, Your Honor.
Yes,
All
sure.
right. Which one is the, oh, there I see that. Let's add to the spotlight. There she is. Hi, Ms. Carpenter.
How you doing? Good morning.
I'm doing okay. Ms. Calloway, what are we doing in Ms. Carpenter's case?
We just received an offer last night, Your Honor, so we're gonna ask the court to hold so we can speak with Ms. Nix about it.
Great. And will that be a Ms. Nix matter, Ms. Dilligard?
Yes, Judge.
Okay. And for the defense attorneys here, we're in a transition from the Nix regime to the Dilligard regime. So you may hear both names. I may look confused, like, wait, why is this with this lawyer? But they are doing their best to have an orderly transition as Ms. Nix goes off to do other things and Ms. Dilligard gets settled into courtroom 8D. So Ms. Calloway, you need to sit tight. You can, whether you stay on the Zoom or not, doesn't matter to me so much as long as you and Ms. Calloway are talking. And then we'll need to get you back on the Zoom to have whatever conversation we're gonna have today. It's a plea, or it's dismissed, or you're saying no thank you, but we have to get on the record that you're saying no thank you to the state's offer, just so we know what it is you're rejecting. And I'll give you some instructions after that. So I leave it to you, Ms. Carpenter, whether you want to stay on the Zoom, but certainly stay in touch with Ms. Calloway, because I will need to see you again later this morning, okay?
Yes, sir.
All right.
Thank you, Your Honor.
Okay.
Larry Lawson. Hello, Mr. Lawson.
Your Honor, we can have a final plea hearing. This is a case that will be going forward to trial.
All right. We will do that at the end of the call of the calendar before we start up with other stuff. All right, Mr. Lawson, you can take a seat in a little bit. I'm gonna have you come up to the podium and we'll get a few things on the record. William Coleman. Good morning, sir.
I'm ready to go and negotiate, please.
Great. Mr. Coleman, we'll try to knock that out this morning, okay? Carolyn Frederick. That's Ms. Frederick? Hello, Ms. Frederick. Good morning.
That should be a plea also, it's gonna talk to her.
All right, Ms. Frederick, Ms. Rios is gonna chat with you once we finish calling the calendar, and it sounds like we may be resolving your case today.
Yes, sir.
Great. Jaquavius Hammond.
Good morning, Your Honor. Alfonso Craft for Mr. Hammond.
Hello, Mr. Kraft.
I haven't had any communication with ADA next, so we do not have a recommendation. I was going to request a reset in this case, Your Honor. I filed several subpoenas. We haven't received any word back on those subpoenas yet. Beyond that, that's my announcement.
Okay, Ms. Dilligard, is this a you case or a Ms. Nix case?
A Miss Nix and me combination. We've been talking about this case. We had some conversations late last evening with the victim. And so I just need to circle around back with Miss Nix when she gets here, but we can discuss.
Good. So Mr. Kraft, at a minimum, since you're here, your client is here, and we have half of the Nix Dilligard team here, and I'm told Ms. Nix is gonna be here. I'm gonna want you all to confer so that you leave today with an offer. It may be you hear the offer and say, actually, I leave today with a plea. I don't know. That's not compulsory. Because you haven't received one yet, what I would do is we get on the record, whatever it is, but I would leave your client's final plea rights open. I'm not inclined to take it off the trial calendar. He's just not losing the final plea rights, which would mean in 2 weeks or the day of the call of the calendar, we could still go through the process of, it's gonna be non-negotiated, but I'd like the right to withdraw, Judge, if you go in a direction other than what I think you should do, and you'd have that right, we preserve that right. The other thing I wanna talk about once we get Ms. Nix here is, what are these subpoenas, who's not getting you what you need, are there things that the state ought to have gotten you, or this is third-party stuff? But let's not worry about that right now, I just wanna know what that is, because it may be when I hear that, like, well, January 30th is not gonna work anyway. Regardless of what we do with the final plea. So we will talk, and we'll do that once Ms. Nix is here, and more importantly, after you and Ms. Dilligard and Ms. Nix have had a chance to talk about where the state is on this.
Thank you.
You're welcome. And then we have co-defendant Quantavious Hammond. He is here as well. Ms. Wood.
Judge, I just need to speak to Mr. Hammond, so I'll hold.
Okay. You did receive communication from the prosecutors?
Yes, Judge, and I need to speak with them after I speak with him.
Got it. More talking. Okay. Phineas Jasper.
You should be on the call, Judge. Is he on the Zoom?
Could be. We have one that's just an iPhone, and then yet he's been Nokia.
Yes, I'm ready, Jasper.
All right, there he is, Mr. Jasper. That's Ms. Wood's case. What are we doing today with Mr. Jasper?
I have an updated offer. I need to just call them after the call to see if this is gonna resolve today, Judge.
Okay, you have a good number for him? Great. So Mr. Jasper, you are free to temporarily drop from the Zoom because Ms. Wood's gonna give you a call to talk a little bit more about your case. You and she will then come up with a plan, whatever you're gonna do. But you'll need to get back on the Zoom so that we can have on the record you, me, your lawyer, and a prosecutor, a discussion about, is it working out today or is it moving to the trial calendar, okay?
Okay then.
All right, I will see you soon. You're welcome to drop off because Ms. Wood's gonna need to talk to you.
Okay then. Okay. Thank you.
You bet. Michael Ross.
Yeah, you can leave.
And he is another Ms. Cabrera case. Co-defendant is Cynthia Johnson. That's another one in custody. And she's not here yet?
She's probably.
Okay, that's Mr. Francis. I don't see him here, so we'll work on.
We're holding for his report, Judge.
Okay, great. And then there's a third co-defendant in that case, and that's Dominique Wright, also in custody, and that's Mr. Render. All right, is number 17 a male or a female? A male, so he's here.
Yes.
He and Mr. Ross are here. We don't have any defense attorneys here. Okay, Ms. Dilligard, your case or Ms. Nix's?
It'll be my case, Judge.
Have you had contact with any of these lawyers?
I emailed them yesterday offers. I haven't heard anything back just yet.
Okay, we'll see what happens. We also have a plea scheduled for Mr. Newsome. I saw his lawyer here. I see Mr. Miller here. Good morning, sir.
Good morning, Your Honor. It's my understanding the defense counsel did step out to speak with Mr. Newsome, but it's my understanding also that this matter is set for a plea today.
That's what was asked to happen. So we can do that. I think when some of the other lawyers are huddling up and talking, maybe we'll knock that one out.
Absolutely, Your Honor.
Okay, you're ready to go forward.
I am, Your Honor.
Okay, thank you. And then finally, is Mr. Woods here?
I think he might be on Zoom, Judge.
Okay,
I'll be here.
he's here. He is the iPhone. Let's see. There he is. Hey, Mr. Woods, we're gonna take a plea in your case. Got a couple things I'm gonna do first, and then is it ready to go, or you need?
I just need to talk to him very briefly about the structure of it, so if he could also drop off and I'll call him.
Okay, I don't know if you're able to hear that, Mr. Woods, but Ms. Wood, your lawyer, is asking you to drop off the Zoom temporarily so she can talk to you about your plea, just so there aren't any surprises when we have our conversation, okay?
Okay.
All right, we'll see you soon.
Okay.
All right, so I think what I'd like to do then is let's have the final plea discussion with Mr. Lawson, where he can get out of here. And then Mr. Miller stepped outside. We should take the plea in that because it's ready to go, and then lawyers can start talking. Mr. Lawson, you come right up to the podium, be there in front of the microphone, please.
Please stop this, man. I got shot, man.
Would you like to sit?
No, I'm saying I got shot, man. These people keep. I got
No,
two.
Hey, Mr. Lawson.
I'm with the 2 jobs. Come this bullshit, man.
Mr. Lawson, come this way, please, and stand.
Right here.
Ms. Rios, you ready? And Ms. Beza, is this your case?
Yes, Your Honor.
Good morning.
Good morning, Your Honor.
All right, Ms. Rivers, you ready to start this morning's record?
Yes, I am, Judge. Good morning.
Good morning. We're getting on the record in 24 SC 003886, State versus Larry Lawson. Mr. Lawson is here in court today with Ms. Rios, his lawyer, and we have Ms. Beza from the state. Ms. Beza, if Mr. Lawson wanted to, well, first of all, Mr. Lawson is charged with aggravated assault, family violence battery. If Mr. Lawson wanted to resolve his case today, what would the state be recommending?
We'd recommend a no process count 1, so dismissing the aggravated assault, pleading to the misdemeanor battery family violence, 12 months probation, family violence intervention program, and no contact with the named victim in this case.
Who is?
Ms. McCrary.
All right.
McCary, and the first name.
Ms. McCrary is fine, that's all. Okay, that's all I need. So Mr. Lawson, good morning again. If you wanted to resolve your case today, you don't have to, but I'm just letting you know what the state's offer is today. I need you to tell me you understand it. You're charged with a felony and a misdemeanor, and the state, having reviewed the case and maybe having had interactions with Ms. McCrary, saying they're prepared to dismiss the felony, the more serious charge. That goes away. And what you'd be pleading to is family violence battery, which is a misdemeanor. You'd be on probation for 12 months. You'd have to complete the family violence intervention program. And perhaps most importantly, you need to stay away from Ms. McCrary. Do you understand what the state's recommendation is?
Did you read this here?
So my question is whether you understand. I'm gonna let you tell me what you want to tell me in a minute. Did you understand what the state's recommendation?
I don't want to sit. No, I'm going straight to court.
Okay, so you'd like to go to trial. Ms. Rios, how are you doing with discovery?
I believe I have all of the discovery that is out there. I'm gonna double check. And there's some subpoenas that I've done that I'm waiting to hear back for. So I'm not completely sure I'll be ready on the 30th if I have everything back possibly.
You are trying to get what kind of
records
information?
from the cell phone records, subpoenaing her cell phone records.
Meaning Ms. McCrary's?
Yes.
Okay, got it. Let me look. right. Mr. Lawson, you've told me you understand the state's offer. You're saying no thank you to that. You'd like to go to trial. What is it? There's something else you've been sort of waving around in court.
I said, did y'all even read this? Man, she ain't said I did none of this stuff. She got detained, man. I work with 2 jobs, lost my job. I've been a slave for a whole year with ankle monitor around. I'm working 2 jobs, lost my job because they said, this lady knows she don't have a case. Man, everybody keep asking me, I'm working 2 jobs, man. Okay? And they keep bringing me to court for this here, man. I the one got shot. I was leaving that night. Okay? Mom said, why y'all keep, anybody read this here?
I'm not sure what you're holding in your hand.
The paper that when the police came in first, she never said I did none of these things to her until she got detained.
Ms. McCrary got
Yeah, she never said I put my arm or nothing. I was leaving that night.
Okay.
Nobody read this stuff. It's in the police report. Nobody doing their job. I'm sitting somewhere trying to make me a slave for nothing, man.
All right. I don't think anyone's trying to make you a slave, but my role in the process is not to read the police reports. I read the things that the lawyers file. Your lawyer has filed a motion to modify your bond. I modified your bond after we had a discussion about that. So Ms. Rios has been doing exactly what she's supposed to do. My understanding is that you don't have an ankle monitor anymore.
No,
because your lawyer did what she's supposed to do.
I'm saying, but I got a rod in my leg for the rest of my life. I got that for the rest of my life. I got shot. I got a rod in my leg for the rest of my life.
Okay. Well, I'm sorry you got shot. I'm here to work through your case.
Yes, sir.
And you're telling me no thanks to the offer. You understand then that we'll see you on the 30th.
Okay.
You'll need to be here in court. I know it gets you frustrated when you have to come to court, but you'll need to come back on the 30th. That's the day we call the trial calendar. And we'll figure out where in the process we'll do your trial. And in the meantime, Ms. Rios is working on your case. Sounds like she's trying to get some information about Ms. McCrary. This offer that you got today, the dismissing count 1 and just probation for count 2, I need you to tell me that you understand that there's no guarantee that's the same offer at the end of the month. You may have a change of heart, say, wait a minute, I want to take that.
I'd rather go to prison, man, before I even let the people railroad me. I'd rather go to prison, man. Come on, get up out of here. So I thank you so much for your time, but I got to go to work.
What are your 2 jobs?
I was a truck driver, now I work at a car wash, okay?
That's
one job, then I work at car wash. I'm working 18 hours a day. I got to catch model, okay? I had to catch model way from over here out of South. Fulton County over here, on Stone Mountain out here. Take me 2 hours to get here. Okay, I'm getting 3 hours worth of sleep, man. And these people keep messing with me. You know she ain't got nothing, man. Ain't by her own words. She ain't said I did none of this stuff.
Okay, don't hit your lawyer with the papers, all right?
I apologize. I'm just frustrated, man. This shit.
I can tell you're frustrated. And
3 hours of sleep, man. People keep messing with me, man.
Okay. All right, Mr. Lawson, I'm gonna let you go and we will see you on the 30th.
All right.
Your Honor, that concludes my statement. Can I be excused?
Yeah, you may want to let Mr. Lawson go first. All right, Mr. Miller, have you tracked down the defendant and his lawyer? Because I'm ready to take that plea while we let the lawyers on all the other cases confer.
Your Honor, yes, they are outside the courtroom. However, they are filling out the paperwork for probation. There are several documents that I will submit on the record during the plea, and they're going over those documents with their client at the moment.
Okay. All right. Is there anything else that's ready to go right now?
I have a plea that I already went over the waiver, so we can go like right now.
Let's do that. Who's that?
William Coleman already sent an email. The negotiator.
Got it. And was Mr. Coleman one of our virtual defendants, or he's here? Great. Mr. Coleman, come on up to the podium, please. Good morning, Ms. Nix.
Good morning, Judge. Apologies for my tardiness.
Oh, it's been a little spicy here already. And is Ms. Dilligard doing this or is Ms. Nix?
I'm gonna do this one.
You're gonna do it. Great. Okay. If you don't mind coming to the witness box, that way I can get you on the screen so that Ms. Rivers is able to see everything. Ms. Rios, we're not on the record for this, but what I took from your comments in Mr. Lawson's situation is that it's not that the state hasn't gotten you things, but on your own, you're trying to get things, and that's okay. Okay. I don't know that he wants a continuance. All right, let's get on the record. In position 10, it's 24 SC 003915, State versus William Coleman. Mr. Coleman is here in court with his lawyer, Ms. Rios. Ms. Dilligard is the prosecutor. And Mr. Coleman, my understanding is you're ready to go forward with a plea. Is that correct?
Yes, Your Honor.
All right, Ms. Dilligard is going to put you under oath in just a moment. Once you're under oath, you need to answer her questions and mine, because I'll have a few, truthfully and completely. If you have any questions at any point, you should let me know, because I need to be comfortable you're following what's going along, right?
Yes.
Great. When you're ready.
Mr. Coleman, can you raise your right hand? Do you swear and affirm that any statement or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You put your hand down. Please state your true, correct, and legal name.
William Coleman.
Are you at this time taking or under the influence of any medicine, drug, or alcohol?
Medicine, yes.
What is that medicine?
I have schizophrenia. I take medicine for it.
You have, pardon me?
Schizophrenia.
Okay. The medication that you take it when during the day?
I take it once in the morning and once at night.
Did you take it this morning?
Yes.
When you take it, does it make you drowsy or woozy or confused?
No, sir.
Okay. You feel like you're following what's going on in court today?
Yes, sir.
How long have you been taking that medication?
I was diagnosed, I was in the military. I was diagnosed with schizophrenia by them like maybe 3 years ago.
Okay,
So
but you've been taking it pretty regularly since then?
Yes, sir.
Great, thank you.
Mr. Coleman, how old are you?
I'm 29.
And how far have you gone in school?
High school completed.
And is English your dominant language?
Yes, ma'am.
You understand that you have been charged with the following offenses: 1 count of aggravated assault.
Yes, ma'am.
You understand that you have the right to plead either guilty or not guilty to that charge?
Yes, ma'am.
You understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the waiver of rights form with your attorney?
Yes.
And did you sign it?
I didn't sign anything.
We went over it.
Oh, we went over it.
Okay. Have you had enough time to speak with your lawyer about all the charges, this one charge in this indictment, including the facts and circumstances related to the charges?
Yes.
Would you like more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
Yes.
Do you waive any and all defects in the indictment for the purposes of this plea?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you remember being arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for this charge that you're pleading guilty today?
Yes.
The minimum being 1 year and the maximum being 20 years?
Yes.
You understand that today you're entering a negotiated plea of guilty, which means that the state will be recommending the following sentence. For count 1 aggravated assault, 5 years probation, to stay away from all auto zones, no contact with the victim, 100 hours community service, and an anger management course.
Yes.
You understand that the court is not required to accept the state's recommended sentence?
Yes.
You understand that the court has the right to sentence you to the maximum possible sentence on this charge being 20 years?
Yes.
Do you understand that the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do You understand that if you're on probation, you must follow all the conditions of your probation.
Yes.
You understand that if you fail to follow all the special conditions of your probation, that you'll be subject to revocation of that probation for the balance of your sentence.
Yes.
You understand that you're not allowed to possess or use a firearm while on probation.
Yes.
Are you a United States citizen?
Yes.
You understand that if you're not a citizen, a guilty plea conviction will affect your immigration status.
Yes.
You understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm.
Yes.
You understand that doing so will result in new criminal charges for which you will face an additional sentence.
Yes.
You understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime.
Yes.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty to a felony in the state of Georgia?
No.
Have you ever pled guilty to a felony in any other jurisdiction?
No.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
You understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status can be revoked.
Yes.
This means that you can be adjudicated guilty and can be resentenced up to the maximum sentence for this charge in this indictment. You understand?
Yes.
You understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses.
Yes.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial.
Yes.
Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Coleman, how do you plead to the charges of aggravated assault, indictment number 24 SC 003915?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
You understand that for a felony charge, you only have 4 years from today to file that petition?
Yes.
At this time, do I get factual basis for the charges?
Yes, ma'am.
On February 25th, 2022, Caleb Wilson was working at the AutoZone at 5345 Campbellton Fairborn Road when the defendant came in to return an item. Wilson, the victim, told Coleman that he could not get a 100% cash refund, which upset the defendant. He became irate, went behind the counter, pushed the victim. He began screaming and knocking things over. Coleman, the defendant, threw various items, including bottles of brake fluid, industrial cleaner, at Wilson's head and face. It's the bottles and the brake fluid and the industrial cleaner struck the victim in his head, causing a laceration. The officers responded to the scene, but the defendant had already left. The AutoZone manager provided video footage of the incident to officers, which shows the defendant throwing the bottles at Mr. Wilson's head. He was identified by a receipt that had his name and telephone number on it. Officers showed Coleman's driver's license picture to the victim, who then confirmed that Mr. Coleman was his assailant. All this occurred in Fulton County, Georgia.
All right. And your office has spoken with Mr. Wilson?
We've made multiple attempts to contact the victim, unfortunately no success.
I guess this happened almost 3 years ago, so. Okay, got it. Thank you. Good morning, Ms. Jackson. Thank you for joining us.
Good morning, Your Honor.
Can you share with me any criminal history information you have, please, on Mr. Coleman?
Yes, Your Honor. He has 2 cycles. The last arrest was April the 14th, 2019, in Decatur, Georgia, with theft by taking, a misdemeanor, and simple battery. He does have 1 misdemeanor conviction that was in 2019 out of DeKalb County for theft by taking and simple battery. Nothing in addition, Your Honor.
Thank you. Ms. Rios.
Yes, Your Honor. Mr. Coleman is 29 years old. He completed high school. He was in the military. He was honorably discharged due to his medical condition surfacing. And right now he's working at a hotel as a vent staff. He has 1 child who's 7 months old. I ask that you accept the plea as negotiated. I sent you his proof of the military and that he's working and things. So he's been doing good since this incident. Of course, with his medical condition, I think maybe he's just having a bad day. He did say the victim in case it was more of a mutual thing than it appeared, but he understands how it looks. So he's willing to take a plea today. I'm asking for him to be treated as a first offender. Also asking for a behavioral discharge date of within 3 years. And that's all, Your Honor.
Okay. Mr. Coleman, what branch of the military did you serve in?
Navy, sir.
Right. Were you ever deployed overseas?
No, sir.
How long were you in the Navy?
1 year before I got medically discharged.
Okay. And what hotel are you working at now?
It's called the Inn at Serenbe. It's in Chattahoochee Hills.
Oh, that's pretty fancy. What do you do there?
I'm event staff, so we have like conferences like Chick-fil-A, Coca-Cola. We have weddings. Also work in the restaurant as well.
Okay, got it. And you have a young boy or girl?
Boy, sir.
What's his name?
Chance.
Chance?
Yes, sir.
And does Chance stay with you, his mom, or where does Chance stay?
With me.
Okay. Who else is in your household?
I rent out a room to a friend,
So you and Chance, and then a friend is in another room? That's it? And I don't need your street address, but are you down in Chattahoochee Hills, or where do you stay?
I'm in Jonesboro.
Jonesboro, okay.
Yes, sir.
All right. Anything you want to add or any questions you have?
Only thing I want to add is, or I say is, that incident is not me. Yeah, I was diagnosed with schizophrenia, but I feel like throughout my whole life I behaved differently. I wasn't on my meds at the time, and I was definitely having a bad day.
So talk to me about that middle part, that you weren't taking your medicine at the time, because we talked about your medicine early on in this conversation, that you were diagnosed a while ago and you fairly regularly been taking medication to help address that. Why in February of 20 had you not yet begun taking the medication?
Well,
or you decided I'm gonna take a month off? When I first
got out of the military, I wasn't diagnosed with anything. I just had a mental condition, and it took several years, maybe about 3 or 4 years, before I even went to the VA. And then that's when I was diagnosed. When I first got my meds, I wasn't taking it seriously, and I wasn't taking my medicine. After that incident, since then, I had gone to the VA. I had got reevaluated, and then that's when I started taking.
This helped focus you on the importance of treatment.
Yeah, because exactly, it made me realize it was important to take my medicine.
That makes sense, and there's been nothing bad going on since then, February of 2022. Okay, I need to talk to you real briefly about first offender. For first offender, you have no felony conviction, so it's a good opportunity. It means that this is not a felony conviction. If I sentence you as a first offender, that helps with work. If you want to go back to school, all sorts of things, because you don't have to check that box, because you won't be. That's the upside. The downside is that if while you are on probation for this, there's another situation, you get arrested, you get charged with something, those new charges can be a basis for the state to say, oh, we need to revoke first offender. And then without a trial, you'd have a hearing, but you've already admitted you did these things. I could resentence you. It would then become a felony conviction. And and I'm making this up, I'm assuming it won't happen, but if a year from now, you're in a Pep Boys and you throw a wrench at some guy and hit him in the head, we'll be back here and you'll have that new situation, having hit someone with a wrench. And I might say, well, we need to do 5 years to serve on this one, because your whole story about that's not me and I'm changed, well, wouldn't have been real accurate because something else happened. I don't think that's going to happen to you. You've got a great situation and a wonderful child and all that. But I need you to tell me that you understand, assuming you do, that there's a risk to first offender. It's not just, sweet, I don't have a conviction. If it blows up on you, there are consequences. Do you understand that?
Yes, sir. I did have one question about that. She recommended 5 years. I did talk about maybe getting less than 5 years.
That was in behavioral incentive date that I asked for. So he's on it.
Oh, okay, yeah.
I'll talk about that in a minute, but I understand you. Do you understand me when I talk about the risks and benefits of first offender?
Yes.
Knowing those, do you want to be sentenced as a first offender?
Yes, sir.
Okay, I will do that. Mr. Coleman, I find there's a factual basis for your plea. I understand that if we watched a replay of it, it may well be that Mr. Wilson got in your face some as well, but you are telling me you don't want to go to a jury and have the jury hear everything, and maybe it doesn't come out so well for you. I do find there's a factual basis. And that your plea is knowing and voluntary. Voluntary means no one's forcing you. Knowing means you've understood all the things we talked about. Do you agree with that?
Yes.
I'm sentencing you pursuant to the Probation Options Management Act, which means, hold on one second, that while you're on probation, if you have a small violation, I hope you have none, but if it's small, maybe you miss a meeting, you and probation will work that out. You don't have to come see me. But if it's something big, you get arrested again, or AutoZone is calling saying, why is this Coleman guy here in AutoZone? That's the kind of thing that will come back to me. Ms. Rios, can someone in my office sign the indictment indicating the guilty plea?
Yes, sir.
Ms. Dilligard, can we sign for you?
Yes, Judge.
Mr. Coleman, can we electronically sign the indictment showing your guilty plea?
Yes.
Do you have a weapons carry license?
No.
All right. As said, I'm treating you and sentencing you as a first offender, and I'm going to sentence you to 3 years probation on count one, the only count. Special condition number 1 is to have no contact with Caleb Wilson. I know he's a stranger to you, but don't look him up to try to say sorry or look what you did to me. Number 2, you need to stay out of auto zones. Number 3, you'll need to do 100 hours of community service. That's a lot of hours, so get going on them. Don't wait till year 3 to do that. And I encourage you to be creative in how you do them, because if you just show up and say probation, do you have any ideas? They'll say, sure, you can pick up trash on the side of the road. And that's a waste of your talents and your time. But if you find an organization where you can volunteer and they can keep track of it, you may well be able to do your community service coaching or working at a food pantry or something like that. There are all sorts of options that you might find a little less drudgery than picking up trash on the side of the road. You will need to take an anger management course. Probation can help you find that. And I'm not setting a behavioral incentive date because I think given how long ago this happened and the fact that there have been no incidents since then, and you've been pretty rigorous in taking your medication, that 3 more years of making sure you stay out of trouble gets us to almost 6 since this incident. So I'm setting it at 3 years probation and no behavioral incentive date. Anything else, Ms. Rios, on behalf of Mr. Coleman?
No, Your Honor, thank you.
Ms. Dilligard, on behalf of the state.
Nothing further.
All right, Mr. Coleman, before you go, we have Ms. Simpson from probation. She needs to give you reporting instructions. It sounds like you're in Clayton County, so she's going to be getting you an address in Clayton County where you need to report for probation. So listen up, and hopefully Ms. Rios can leave you with a piece of paper with those specifics, okay?
Yes,
All
Your
right.
Honor. Thank you.
You bet.
So, Mr. Coleman, I just need a current address for you,
You want me to tell it to you?
if you don't mind it on record.
Mr. Miller, while they're doing that, are we at last ready to go in that Mr. Newsom case? Great, if you guys want to start working your way up.
Excuse me, did probation want to record?
We may get something on the record. We won't start the nuisance. I'm just getting everyone up here. I'm just letting Mr. Coleman finish that, and we'll see if there's anything they need to say on the record.
Yes, Judge, I'm talking about Mr. Coleman's address.
Oh, no, that's off the record right now.
Okay, thank you.
This is mine.
Your Honor, it's my understanding that during the plea, the court will sign defenses, sign the indictment on behalf of the defense and the prosecutor. Is that correct with our consent?
Right, we won't have a paper indictment moving around. We may have other documents like the rights form or the conditions like that. Those are, I'll verify those signatures, but then we'll have a discussion about, we'll electronically sign the indictment.
Okay, thank you.
Ms. Simpson, are there any reporting instructions you want me to get on the record for Mr. Coleman? Sit tight, Mr. Coleman.
Yes, he has his report instructions to report to his Clayton County Probation Office on January 23rd at 8 a.m.
January 23rd at 8 a.m. at that address you've got on a piece of paper, okay?
Yes, sir.
All right, good luck.
All right, thank you.
Bye. Thank you. All right, next matter is State versus Newsom, 24 SC 004430. Mr. Newsom is represented by Ms. Merchant. Good morning.
Good morning, Judge. Good to see you.
Good to see you. Mr. Newsom is here, and there is another person up at the podium.
Judge, I'm Larry Cohn. I'm also co-counsel with Ms. Merchant on this case. KOHN, Larry Cohn.
KOHN. All right, Mr. Cohn. And we have Mr. Miller as the prosecutor. Mr. Newsom, in a moment, Mr. Miller is going to put you under oath. You may have watched what happened with the previous defendant, but it will be similar. A bunch of questions about your rights. You'll need to let us know your responses. If at any point you've got a question or you need to speak privately with Ms. Merchant and or Mr. Cohn, that's fine. Just let me know. I need to be comfortable that you are asking the questions that you have. All right? And you'll need to speak up a little louder for the court.
Sorry. Yes,
okay,
Your
for
Honor.
the court reporter. All right, Mr. Miller, when you're ready.
Thank you, Your Honor. Mr. Newsom, could you please raise your right hand? You swear or affirm that the testimony you shall give in this matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You may lower your hand. Mr. Newsom, please state your true and correct legal name.
Joshua Forrest Newsom,
And could you spell your first and last name for the record, please?
JOSHUANEWSOME.
Mr. Newsom, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medication that you normally take that you have not been given today?
No.
Mr. Newsom, how old are you and how far did you go in school?
I'm 46 years old. I completed a Bachelor of Science in college.
And so you're able to read, write, and understand the English language?
Yes.
Mr. Newsom, do you understand you are charged with the following offenses in indictment number 24 SC 004430? You are charged with 7 counts of sexual exploitation of a minor pursuant to OCGA 16-12-100, Section B, Paragraph 5. Do you understand?
Yes.
You understand that you have a right to plead guilty or not guilty to these charges. And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Mr. Newsom, have you reviewed the waiver of rights form with your attorney?
Yes.
And is this your signature on the last, second to the last page of this document?
Yes, it is.
Now, did you have enough time to speak with your lawyers about all the facts and circumstances known to you about the charges in this indictment?
Yes.
Do you need more time to discuss this case with your attorneys?
No.
Are you satisfied with their services?
Yes.
Counsel, do you waive formal reading of the indictment?
Yes.
Counsel, do you waive any and all defects in the indictment, including any with respect to your client's name?
Yes, we do.
Mr. Newsom, have you been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
No.
Mr. Newsom, has your attorney advised you of the minimum and maximum sentence for each charge you are pleading guilty to today?
Yes.
So for example, the charge of sexual exploitation of a minor carries a sentencing range of 5 to 20 years in custody. Do you understand?
Yes.
You understand that this is a negotiated plea, which means the state will recommend to the court the following sentence. For count 1, sexual exploitation of a minor, 10 years probation. Count 2, sexual exploitation of a minor, 10 years probation. Count 3, sexual exploitation of a minor, 10 years probation. Count 4, sexual exploitation of a minor, 10 years probation. Count 5, sexual exploitation of a minor, 10 years probation. Count 6, sexual exploitation of a minor, 10 years probation. And count 7, sexual exploitation of a minor, 10 years probation, with all counts to run concurrent with one another. However, the court does not have to accept this recommendation. The court can sentence you to the maximum on each charge and can run those sentences consecutive or concurrent. Do you understand?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes.
You understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions or probation without being subject to revocation for the balance of the sentence?
Yes.
Mr. Newsom, do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are pleading guilty to a crime against a minor, including kidnapping, false imprisonment, or conduct of sexual nature involving a minor, or if you are pleading guilty to a dangerous sexual offense as defined by state law, you will be required to register as a sex offender?
Yes.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would? And that is true regardless of any advice by your attorney or anyone else?
Yes.
You understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections or Board of Pardons and Parole, and no one can guarantee parole no matter what anyone has told you?
Yes.
You understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial. For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes.
You understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison.
Yes.
You understand that you waive any and all defenses, including any mental health defenses, by entering a guilty plea today?
Yes.
You understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, however, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand?
Yes.
Mr. Newsom, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Mr. Newsom, how do you plead to the charge count 1, sexual exploitation of a minor in indictment number 24 SC 004430?
May I ask a question?
Yeah.
Guilty. Guilty.
Mr. Newsom, how do you plead to count 2 in indictment number 24 SC 004430, the charge of sexual exploitation of a minor? How do you plead to that charge?
Guilty.
How do you plead to count 3, sexual exploitation of a minor in indictment number 24 SC 004430?
Guilty.
How do you plead to count 4, sexual exploitation of a minor in indictment number 24 SC 004430?
Guilty.
How do you plead to count 5, sexual exploitation of a minor in indictment number 24 SC 004430?
Guilty.
How do you plead to count 6, sexual exploitation of a minor in indictment number 24 SC 004430?
Guilty.
And how do you plead to count 7, sexual exploitation of a minor in indictment number 24 SC 004430?
Guilty.
Mr. Newsom, is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
You understand that you have only 4 years from today's date for a felony charge to file what is called the habeas corpus petition, challenging the constitutionality of this guilty plea?
Yes.
You understand that you have a right to withdraw the plea, but you have to do so before the term of the court expires?
Yes.
You understand that you have 30 days from the date of the sentence being entered to file a direct appeal?
Yes.
And Mr. Newsom, prior to entering this plea, what I'm showing you is a document that is labeled General Conditions of Probation. Did you go over this document with your attorneys?
Yes, I did.
And Mr. Newsom, are these your initials and is this your signature on the last page of this document?
Yes, it is.
Mr. Newsom, does your initials and your signature on the last page of this document indicate that you agree to adhere to the terms and conditions listed in this document?
Yes.
Mr. Newsom, what I'm now showing you is a document that is entitled Sex Offender Special Conditions of Probation. Did you go over this document with your attorneys?
Yes.
Now, is this your initials and is this your signature on the last page of this document?
Yes.
Does your initials and your signature on the last page of this document indicate that you agree to adhere to the terms and conditions in this document?
Yes.
Mr. Newsom, what I'm now showing you is a document that is entitled Department of Community Supervision's Restrictions for Computer Usage. Did you go over this document with your attorneys?
Yes.
Mr. Newsom, are these your initials and is this your signature on the last page of this document?
Yes.
Does your initials and your signature on the last page of this document indicate that you agree to adhere to the terms and conditions here in this document?
Yes.
And lastly, Mr. Newsom, what I'm now showing you is a document that is entitled Department of Community Supervision's Mandatory Submission to a Polygraph as Conditions of Probation. Did you go over this document with your attorneys?
Yes.
Did you have any questions regarding this document?
No.
And is this your signature on the last page of this document?
Yes.
And does your signature on the last page of this document indicate that you agree to adhere to the terms and conditions in this document?
Yes.
Thank you, Mr. Newsom.
May I ask a question? Can I talk to you for a second, if you don't mind, Arnold? In regards to the conditions, I believe there may be one page that sounds like we may be missing out of those conditions that.
Okay, let's clear that up so we're not overlooking anything that needs to be included.
No. He doesn't have a curfew. Right. That's a registration requirement. It's not a registration requirement.
Yeah.
We can address that with the court at the appropriate time.
Can we keep going?
We can, Your Honor.
Okay.
Your Honor, had this case gone to trial, the state would have been able to prove beyond a reasonable doubt that on January 4th of 2022, Special Agent Haley Peacock of the Georgia Bureau of Investigations was conducting an online investigation on the BitTorrent network for offenders sharing child sex abuse material, also known as CSAM. Special Agent Peacock directed the investigative focus to a device at IP address 99.29.82.204 because it was associated with 70 torrents of interest. The subject using the IP address was observed on the BitTorrent network as being in possession of 100,000 files of interest, of which 14,000 of those files were categorized as severe files. Now, severe files are files with hash values that are known to law enforcement to depict images or video of child sex abuse material. Now, they are generally labeled as being severe because they involve sexual abuse of children. Of the 14,000 severe files, 7,000 of the files depicted abuse of children. Special Agent Peacock noted that law enforcement was running undercover tools on the BitTorrent network. Investigator Mike Duncan and investigator Jason Brooks received downloads of child sex abuse material from the targeted IP address by way of peer-to-peer sharing. According to investigator Brooks, on January the 3rd, 2022, around 10:50, he successfully completed the download of at least 11,000 pieces of torrent with info hash that indicated it was CSAM. The following is a description of 5 of the files that he was able to download from the subject's device distributed.
Are the files you're about to describe files that are charged in the indictment?
Yes.
Okay.
Yes. So the first file depicted an adult male engaging in digital penetration with a female minor child. One of the second files that was labeled Special 6 as the file name, it depicted an adult male engaging in oral to genital and genital to genital sexual intercourse with a female minor child. The third file depicted a adult male, depicted a minor female child fully nude while engaging in oral to genital and genital to genital sexual intercourse with an unknown male whose face was covered. The next file depicted female minor child engaging in genital to genital sexual intercourse with an adult male. And then the other file, the last file, depicted several female minor children engaging in genital to genital sexual intercourse with an adult male. Investigator Mike Duncan had indicated that he was also able to download files from the suspected IP address as well. Here's the description of 2 of the files that he was able to download. One file depicted an adult male engaging in oral to genital and genital to genital sexual intercourse with a female minor child. And then the other file depicted 3 prepubescent minor female children fully nude, taking turns digitally penetrating one another. On January 21st, Special Agent Peacock received a subpoena response from AT&T in reference to the subscriber information associated with the IP address that she submitted on January 4th. The subscriber information indicated as follows: the return information coming back to a Joshua Nome at 70 Northern Court in Johns Creek, which is in Fulton County. On Tuesday, February 15th, Special Agent Peacock obtained a search warrant for the residence. And during that time, they were able to see several digital devices. However, there were several that were seized and triaged for child sex abuse material that did not possess any child sex material. However, when it came to a Kindle notebook and a Dell computer, they were able to determine that the Dell computer had files that matched the files that were downloaded by the agents during the investigation. While on scene, the accused was Mirandized and the defendant did agree to speak with law enforcement. The accused admitted to viewing CSAM on the Kindle Fire and the Dell laptop. Digital forensic investigators found files indicative of child sex abuse material on the Dell computer located inside the defendant's bedroom. The defendant did state that he was the only person who used the Kindle Fire, and the Kindle Fire and the Dell laptop was seized now. Your Honor, based on state's review of the file, review to our understanding of the defendant's criminal history, he does not have a criminal history. Based on the investigation by Special Agent Peacock, no female minor children were injured by this defendant, nor were they transported. Given that, Your Honor, the state and defense has agreed to deviate from the sentencing guidelines listed in OCGA 1710-6.2. And because of that, the state is recommending a sentence of 10 years probation on all counts to run concurrent. It's also our understanding that as this case has been pending, the defendant has submitted to counseling as well, Your Honor, which is one of the reasons as to why the state was agreeing with the sentence that is recommended to the court at this time.
Okay, a couple questions. One, if you weren't moving to deviate, what is it? Is there a mandatory minimum that involves incarceration, or what is it that is non-minimum? Because 10 years probation is more than 5, and the range you gave me was 5 to 20.
Right. So yes. So according to 1710-6.2, he would have to at least do the minimum of. It would have to be a term. You have to do the minimum, but he also has to do at least 1 year probation. So 6 serve 5 would be the most that he could do, the lowest he could do based on the statute.
Okay, let me look something up. Okay. Other question, you didn't indicate any special conditions of probation independent of the whole roster of the items that Mr. Newsom is signing up for. Were there any additional, or you're satisfied that the sex offender conditions of probation, and I think you had another list of conditions, that addresses whatever concerns the state has?
With the addition that the defendant, thank you, Your Honor, with the addition that the defendant continue to undergo counseling and treatment as he has been doing so as this case has been pending.
Okay, I'll need that to be a little clearer, in particular for Mr. Newsom. Is it the state's request that Mr. Newsom receive counseling all 10 years of probation, or until a expert says counseling isn't productive anymore, or is there a certain period that you're recommending Mr. Newsom continue to get counseling?
Your Honor, because this case has been pending for the past 3 years, then I will submit that it will be after the counselor has indicated that counseling is no longer needed for Mr. Newsom.
And I can provide some clarity on that maybe as to what he's been recommended for, if that helps the court.
That'll be helpful. I'll let you get to that in the natural flow of your presentation.
Okay.
I just wanted to make sure there was nothing else from Mr. Miller. Thank you.
Thank you, Your Honor.
Ms. Jackson, good morning. Do you have any criminal history information on Mr. Newsom?
Your Honor, he does not have any prior arrests on file, nothing in addition.
Thank you. Okay. Ms. Merchant, I'm much more familiar with the federal statutes, and we wouldn't be talking about probation with Mr. Newsom. I don't know why the GBI took this case state rather than federal, but here we are, and we're in the state domain. I don't read 1612-100, which I'm looking at for maybe only the second time, as having a mandatory anything. So I don't know that I'm not disagreeing with Mr. Miller, but I don't know that any sentence sheet that I fill out, final disposition, needs to invoke 1710-6.2, because I think 10 years probation falls within that range of 5 to 20, and more germane to the point I'm making, I didn't find any language in 1612-100 that says it's not probatable. It's the standard. It's like aggravated assault, 1 to 20, but you could probate it. So
I agree with your reading.
Okay, all right. And it doesn't change anything the state's recommending. I'm just not going to have 1710-6.2 appear on the sentencing sheet, because I wouldn't deviate on anything from Mr. Newsom. I'm not being asked to deviate. I think if you were trying to get a 2-year probated sentence, I'd need to invoke that, but you are it's only probation, but it's in that range. So that's where I fall on that. It doesn't change the outcome. I just want to have it be as legally accurate as possible. So Ms. Merchant, what you want to share, or Mr. Cohen, I don't mean to say you're in charge. You guys share with me what you want about Mr. Newsom and this situation.
Thank you, Judge. I just want to go over a little bit about what he has done, because I think his taking responsibility immediately for this action has led to where we are today and the recommendation from the state. He has also done a lot of treatment because he was willing to take responsibility immediately. This was a download of adult pornography that had what they ultimately found were 7 images that were child sexual abuse. There's no evidence that he was actively searching for specifically volumes of child sexual abuse, but he has freely admitted that he uses pornography and has issues, has sexually compulsive issues. He immediately sought treatment, immediately took responsibility for this. One of the reasons he's been able to do so much of the treatment, unlike a lot of clients, is he made an admission. So a lot of times we have to get a psychosexual evaluation, but we're not allowed to start treatment because there's no admission. He said, I don't even care if it can be used against me later in court. I'm going to go ahead. I need this treatment. I'm going to go ahead and make an admission. And so he did that back in 2022. He had the psychosexual evaluation by Dr. Kennel Reiner, who is a licensed psychologist, a doctor, a PhD.
Can you spell his last name for the record?
And it's Kendall, Kendall. Last name is Reiner, Reiner. And she actually did the evaluation in March of 2022. And she recommended him for treatment. At that time, she found that based on his psychosexual evaluation, he had about a 4% risk of reoffense. He had one of the factors present. She recommended him for the full 7-phase treatment plan, which is what we normally see. We don't see it this phase. It's normally later on because most people do it on probation, but he actively engaged in it. And he's actually completed 4 of those 7 phases. He's done 77 classes for that already. So he's done a lot. And she has presented us a letter. We've given it to the state, sort of updating the state as he's gone along with the treatment. But some of the things that I just wanted to highlight to the court was he takes full responsibility for his offense. He has done so since he started treatment. He has included his family in the treatment process, and his wife and his oldest son are here. He has younger children that it's not appropriate for them necessarily to be here, but they have all known about what's happening. And that's one of the things that we see with people reoffending. They're keeping it secret from people. He has not done that. He's actively owned what has happened in this case. And so because they're involved in therapy and because they've been involved in this, Dr. Reiner thinks that he is a very low risk, even further than that 4% back in 2022. She has recommended that he continue the treatment, continue aftercare, and because he's done so well, and him doing treatment is what will lead to him not having reoffense issues, that's why the state and the defense has agreed to this and thought that this was an appropriate sentence. Just want to address the one thing that the Department of Supervision had mentioned.
Yeah, before you do that,
Yeah.
Are there a bunch of documents you need to give me?
Yes, Your Honor.
Thank you. Appreciate it.
Let me add one other thing. Judge, if I could just add, just so that you know a little bit about him, he's 46 years old. He has, as the state indicated, there's no criminal history. He's been married to the same woman since 1998, gainfully employed for the last 27 years, 24 with one company, 3 with another company as a software engineer. He's got 4 children, 2 of which have significant health disorders. He's the sole provider for his family. His wife also is here, who has some medical conditions as well, some immune and some, I guess, muscular issues would be the best way I can phrase that. 2 weeks after he was arrested is when he sought the evaluation, the psychosexual that Ms. Merchant mentioned. We believe that he's a terrific candidate for probation, as does the state. I would like Ms. Merchant to elaborate on the provisions the probation officer had brought up.
How old are the other kids in the household?
At this point, 15, or they're 20, I think one would be 25, one would be 20, one would be 15, and the other would be 13. So the 15 and the 13-year-old, those are the ones that reside with him at home. 16 and 16 and 14, I'm sorry.
Time has passed.
Time has passed.
16 and 14, boys or girls?
Boys.
And the state has agreed that that will not be an issue for him to live with them. We've also already pre-court today checked with the Fulton County Sex Offender Registry. His house is sex offender compliant, so there are no issues in terms of that.
When you say his house is, not meaning it's got the right appliances,
No,
but
it
it's not near a
resides-
park, it's not
exactly.
near a church,
Its
whatever
location is
the,
compatible with the code section.
okay. Good thing to do, all right. So there was something about the special conditions you wanted to discuss.
Yes, I just wanted to mention it because probation had brought it up. So this, essentially, it doesn't apply in this case. Probation presented this additional condition of probation document about electronic monitoring. It says that if he is declared a sexually dangerous predator under 42-1-14, which he's not, if he is ordered by the court to wear a GPS monitoring system, then this would apply. That's not part of our negotiations. That's not something that has been discussed as part of this negotiated plea, so it wouldn't
Okay.
apply to us.
Officer Evans, I don't want to set Mr. Newsome up for failure if I exclude an ankle monitoring condition, because it doesn't seem like it quite fits in this scenario. Is that going to create friction with DCS?
No, Your Honor, that's what I was gonna announce, that was only if in fact that Your Honor had ordered that, then that condition would have needed to be.
Okay, but it's good that you flagged it so there weren't surprises. He's leaving. You're like, wait, we got to put this on your ankle.
Thank you.
Yes, Your Honor.
Okay, got it. Okay. Anything else, Ms. Merchant?
No, thank you, Judge.
So, Mr. Newsome, this is a difficult situation for you, I am sure. You're here in public, you're being live streamed, people are hearing about things you did that have no pleasant aspect to them. And I appreciate Ms. Merchant doing her job, which is to say, hey, there were only 7 images. It's actually not what I heard. What I heard was that there were 14,000 files. I have a little background in this space, so I get it when they talk about hashtags and severe files and this and that. And so my first observation is 100,000 files is a big old collection. But I appreciate the observation that it wasn't exclusively child exploitation material, but it's not that there were 7 out of 100,000. It's a higher percentage of that. And it's a percentage level that says to me that anyone who was even mildly curating his collection would have realized what it was. And while I appreciate Mr. Miller saying there's no evidence that you harmed anyone, consumption and distribution and trafficking is harming because it's perpetuating the victimization of those little boys and girls. And it sounds like it was mostly girls. You never laid hands on them, but you made it available to others, and it may feed their habit that is of a sexually violent nature. And I'm not telling you something you don't know. And that's the part that's too bad about this. You are a smart, successful person on many other fronts. But I will add this, I'm not condemning you. You are wired differently than some people because you were doing these things because of compulsions. That doesn't excuse it, but there's a reason why these cases are exceptional, because it's not what everyone does. And I think it's a good sign that you immediately elected to receive treatment and that you were open and honest about it with the people you care about, your family, etc. But it is a scarlet letter that you'll be wearing from here on out. You will be required to register as a sex offender. People can look your name up and it will show at 123 Main Street, whatever your address is, there's a sex offender who lives right there. And that's stigmatic, appropriately so, but that's just something that you're gonna need to work through during the duration of your sentence in this case. And I need to make sure you understand that so that you don't tomorrow call Mr. Cohen or Ms. Merchant and say, wait a minute, I didn't know that was gonna happen. We need to undo this situation. You appreciate that there are these ongoing consequences. I may never see you again, but this sentence sticks with you for a number of years.
Yes, Your Honor.
Okay. Is there anything that you want to share with me? And you may be speaking to a different audience, but you and I are the ones having the conversation. But there may be things that you want people to hear about this situation. There may not be. Your lawyers were thorough and helped me understand from where you came, and in many ways, more importantly, where you've been going since this was brought to light.
May I have just a moment?
Sure.
If it's appropriate, I'd just like to apologize to my family, to my victims, to the court, to everyone involved.
Okay. Well, that's an important thing to say. My guess is, given how quickly you invested in treatment, that you've already said you're sorry to your family many times. This is the next phase of consequences flowing from what you were doing. All right. Well, if you don't have any other questions, I do find there's a factual basis for your plea. And again, I recognize it's a plea to only seven images or videos, but the state has to draw the line somewhere. And my guess is if those poor GBI agents had to look at more, it could be an indictment with 1,000 images. It doesn't really change things. 1,000. If we're only one, your lawyers would have been able to negotiate something different than where we are today. Because while some people might walk away from here saying only probation, probation is the easy part of your sentence. It's all these other repercussions, that scarlet letter that I'm talking about, that you're going to need to wrestle with going forward. So I do find there's a factual basis in that your plea is knowing and voluntary. You understand what we've been talking about and that no one has forced you to enter this plea. I am not sentencing you pursuant to the Probation Options Management Act. And so what that means, unlike all my other cases, if there is any issue with probation, you forget to dot an I, that comes back to me. And you and I, and Ms. Merchant, Mr. Cohn, Mr. Miller, will work through what the consequences are. And that's only because I want to make sure I know what's going on in your case. And I don't want probation to think, this isn't a biggie, we're not going to bug the judge about it. So I will see you if there are any issues. I don't know that there will be. I'm not putting it that way because I suspect there will be. I just want to make sure that I'm part of the conversation if there are any issues. You signed a whole bunch of documents and we will be making those a part of the record. The one document that you didn't sign is the actual indictment. And what we're going to do with your permission is electronically sign your name, indicating that you have pled guilty to all 7 counts of the indictment. Are you okay if we electronically sign for you?
Yes, Your Honor.
Ms. Merchant and Mr. Cohn, we'll get both your names on there.
Yes.
You okay with electronic signatures?
Yes, Judge, thank you.
And Mr. Miller, can we sign for you?
Yes, Your Honor.
All right. Do you have a firearms license?
No.
Okay. I'm going to sentence you consistent with this negotiated resolution to 10 years of probation. As to each count, they will all run concurrently with each other. So that's a total of 10 years. You will be subject to sex offender registration requirements. Those will extend beyond the 10 years. When your sentence is complete, your lawyers can petition to have sex offender conditions eliminated or relaxed so that maybe only some of them apply. But until your probation is over, it's not appropriate to seek that type of relief. Statutorily, that's part of your sentence until you successfully complete your sentence. The only condition that I will add beyond the many that you've already signed up for will be that you complete all 7 phases of the treatment that you've already begun. Sounds like you're 4 for 7, you've got 3 left. But until you complete those final 3 phases, you're going to need to continue to invest in that counseling. And once the counselor or therapist or medical professional can present to probation, yep, Mr. Newsom's done 7 out of 7, then you're going to need to be able to document for probation that you are continuing that counseling. Does that make sense?
It does.
And he does that at Medlin. I forgot to mention.
Medlin,
Yes.
okay.
I knew the court would know what that.
That was the initial, Miss Reiner worked for Medlin and then moved to her own practice, so.
Okay, Medlin it is. Officer Evans or Ms. Simpson, do we need to do anything additional? Well, you give him reporting instructions in just a moment, Ms. Simpson, I know that, but other than me signing all of the different probation forms that he has signed, anything else we need to get on the record concerning his probation?
Nothing further.
Okay,
And the new name is New Foundations, Medlin.
New Foundations,
It's not,
okay.
yes, she moved to a different practice. She worked.
Meaning Dr. Reiner is at
Dr.
New
Reiner was
Foundation,
previously with Medlin,
but the counseling is happening where?
with Dr. Reiner at New Foundations.
Okay.
She was a
Was-
previous employee, left, started her own practice with another psychiatrist, psychologist, and that's who he's been treated with.
Good, then I'll make it clearer on the final disposition. You'll need to complete the full course of counseling at New Foundations.
Perfect.
Mr. Miller, anything else?
Nothing further from the state, Your Honor.
Okay, Mr. Newsome, Ms. Simpson needs to give you some reporting instructions.
Thank you.
If you don't mind, I will speak with him out in the.
Yes, I'll let you do that. I'm just gonna get on the record now, whatever date you're given to report to probation, your address is in Fulton County?
Yes.
So you'll be reporting to Fulton County Probation, which is a couple blocks from here on Memorial Drive. Don't miss that first day.
Yes,
Okay? All right, thank you.
Thank you,
Thank you,
Judge. May we
Judge.
excuse?
Yes, ma'am.
Thank you.
Thank you, Mr. Miller.
Yeah, thank you, Your Honor.
I'm not comfortable doing this weird.
Hey, Ms. Cabrera. You look like you're ready to make an announcement.
I do.
Let me find your clients. So we've got Mr. Murray. Is he still here? He's still here.
Yep, and as soon as Your Honor can take his plea, he has a negotiated plea.
Okay.
It looks like misdemeanor negotiation.
Okay, and then you were popular today. You have Ms. Brown, but I think, had Ms. Brown shown up?
She's here.
She's here, of course she did.
She's here. I spoke with the state. I do have the state's offer. They did send me one yesterday, but there is a little bit more digging that needs to happen. So I was gonna ask if Your Honor wouldn't mind preserving her final plea rights. It may be something that is better for diversion and not for a plea. So if they can have the opportunity to do that, that would be great. So
Okay.
we wouldn't be doing anything with Ms. Brown today.
So what I told Ms. Brown, you hadn't made it here yet, but I told everyone, is that all these cases are on the January 30th trial calendar. I can't remember if you're out by then. I know you've got to leave at the
I
end
have
of
to
the
leave the
year.
29th through February 5th, and I think I have Alonzo Miller left on that calendar, and Ms. Brown will be left on that calendar as well. I gotta check to see if there's anybody.
Well, you may have one more. So we're gonna talk about, you have 3 cases. Everyone on here, today's final plea is going to that trial calendar. So clearly, Mr. Murray won't be. But what that just means for Ms. Brown is that if you are able to work something out, if we could take that plea before the 30th, that's fine with me. We don't need to wait till the 30th.
The sooner the state can let me know something, I'll make sure I get her number before she disappears.
Okay.
Once they can tell me what that is, and we can bring that in ahead of the 29th.
Okay.
That would be great.
Okay, and then you also have,
Michael Ross.
yeah, who is here, he's up.
And I spoke to him, and that is also a plea. I believe is that a misdemeanor plea too?
I don't know, but it's a plea.
There's a reduction on the aggravated assault. Yes.
Okay.
So.
So we'll take care of Mr. Murray and Mr. Ross, which would leave then for the trial calendar, and we don't need to work all that out today. Mr. Miller, which we won't be able to do, and then in theory, Ms. Brown, and then I think you have one of the 4 in Lemons.
I have Lemons.
You have Lemons, okay.
Lemons.
And I have directed Mr. Abate to be working hard with all the lawyers on that case to see if any of them can work out. Let's do that in advance so that for the,
I'll
especially
call
you,
Adam.
since you wouldn't be available for the
I'll
trial.
call Adam, because I've been trying to work with Adam one, that now is forever. But I'll call Adam about
Okay.
that and see if he's gotten anywhere as far as what his offer is. He hasn't been able to convey one yet.
Okay, please do. The second week of my trial calendar, you're back. You're out both weeks of the Emerson one. And so I'll make sure your cases don't get sent to Judge Emerson, because I know you have at least one,
I
it's
have
Judge
one.
Lethbridge's.
Yep, I have one on Emerson already. I sent the email about that.
You did, and so I'll manage that, so that doesn't get called in. But, assuming you are, I don't know if you're coming back swinging, from your break, but
If I
that,
have, yep.
that second week of my trial calendar, is after your leave is over. And I flagged that only because if, let's just make it up, in the Lemons case, the other 3 guys plead and Lemons is the only one remaining. They've all been in jail forever, and
Yeah,
I'd like to do
and
that.
we're trying to, Lemons is not likely to be a trial. It's just that Adam hasn't been able to convey what he thinks is inappropriate.
Got it. Okay, well, he needs to focus on that. But then there's Mr. Miller, who's been in for a long time as well.
Might be a whole nother monster, but we'll find out. I'll go see him this weekend.
Okay.
I talked to Reeves on his way out of the room.
Yeah, I saw him poke his head in here. Okay. Well, let's do this. Ms. Brown, you, as long as you leave a good phone number with your lawyer, Ms. Cabrera, I'm gonna let you go for today. But you may be coming back. You will for sure be coming back if you have not resolved your case on January 30th. So I can see you because that's your trial calendar date. But it sounds like before then, the state may have set something up that you and your lawyer agree to. And frankly, if it's diversion, people don't need to come back to court. I sign a piece of paper, but we'll focus on and I'm not forcing anyone's hand. That may not be what the state's interested in. But Ms. Brown, I'll need to see you on the 30th if we don't resolve your case before then, and I will preserve your final plea rights.
Yes, sir.
Okay.
And then I think Michael, so as far as pleas, Bryant Murray would be easier to do before Michael Ross because Michael Ross has a co-defendant. Cynthia.
Yeah, two co-defendants.
Johnson.
Mr. Francis has one, and then we're trying to track down Mr. Render.
Right, and I think that Cynthia Johnson is going to be a plea. And so I didn't know if Your Honor wanted to do them at the same time.
I'd love to, but that means that getting you and Mr. Francis in the same room, I don't know if
think
that's.
he's downstairs.
Okay, all right.
He's in the building.
I saw him, okay. Ms. Nix or Ms. Dilligard, anything you want to add on Ms. Brown? Because if you think Ms. Cabrera is making this stuff up and it's a 100-year sentence, we just need to manage everyone's expectations.
No, Judge, that's accurate. I did want to also make the announcement for the co-defendant as well, Dontius Brown.
Yeah.
It'll be the same announcement for him.
Okay, was he someone who was on a call? He's here. Oh, he's the gentleman who came in. So we'll preserve his final plea rights, but it's looking like diversion. You are here for trial calendar. So Mr. Brown, if you and Ms. Wood don't talk before the 30th saying the state's offered diversion, and so both of you know, that's typically you do some community service, a little self-reflection, a few things you need to do through a program run by the DA's office. And assuming you do those things, they then drop the charges. Maybe you're interested in that, maybe you're not. But if you are, then we basically put your case on hold during the time that you've committed to take care of those things. And if you meet that deadline, the charges are dismissed. If you don't reach that understanding between now and the 30th, then I'll see both of you on the 30th for the call of the trial calendar, okay? But I'll preserve your final plea rights regardless. So if this diversion thing falls apart, you still have the ability to come in, enter a plea if you want to, and withdraw it if the sentence I give you is different from what your lawyer asked for. That makes sense? Do you need Mr. Brown to stick around?
He's gonna go, Judge.
Okay, all right, thanks.
Judge, and I did want to make you aware that.
Hold on one second. Yes, Ms. Brown?
You're free to go.
Yeah, you too. All the Browns can go. Yes, Ms. Dilligard.
There is a defense attorney here for, in lieu of Mr. Render.
Oh.
Who's right here.
Oh, I recognize her. Yeah. Okay, she's one of his colleagues. Great. Okay, excellent. Why don't we do, because you asked, why don't we do Mr. Murray's plea? Just before we do that, you can come on up, Mr. Murray. Anything else ready to go right after that?
Yes, sir. We have an announcement, Your Honor.
Okay, and you had, don't tell me, let me see if I can figure it out. You already told me. Hey, you have Ms. Carpenter.
Yes.
Is that working out today or not working out today?
No, Your Honor, it's not.
Okay, then after we take Mr. Murray's plea, we'll get that on the record so you and Ms. Carpenter can be on your way.
Thank you.
Okay, all right. How are you all dividing things up?
If something is on the trial calendar for the 30th, it's Ms. Dilligard's. This one had been mine, so I.
Works for me. Ms. Rivers, are you ready?
Yes, Judge, I'm ready.
Great. This is position 3, 24 SC 001215, State versus Bryant Murray Jr. He's here in court with Ms. Cabrera. Ms. Nix is here for the state, and we are going to go forward with a plea. Mr. Murray, that means Ms. Nix is going to put you under oath. Once you're under oath, you'll need to answer all her questions and mine. And if you've got any questions, make sure you let your lawyer or me know, okay?
Yes, sir.
All right, when you are ready, Ms. Nix.
Thank you, Judge. Mr. Murray, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Bryant Murray.
Are you Bryant Murray Jr.?
Yeah, Bryant Murray Jr.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there any medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
I'm 21 years old currently.
How far have you gone in school?
Just high school.
Did you finish high school?
Oh, current,
He's
GED.
working on his GED.
Okay.
Is English your native or dominant language?
Yes.
You understand that you've been charged with the following offenses: count 1, aggravated assault, and count 2, possession of a firearm during the commission of a felony.
Yes, ma'am.
You understand that you have the right to plead either guilty or not guilty to these charges.
Yes, ma'am.
You understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial.
Yes, ma'am.
Have you had the opportunity to review your rights with your attorney?
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes, ma'am.
Do you need more time to discuss the case with your lawyer, Ms. Cabrera?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Ms. Cabrera, do you waive a formal reading of the indictment for purposes of the plea?
So waived.
And do you waive any and all defects in the indictment for purposes of the plea?
Also waived.
Mr. Murray, do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes, ma'am.
You understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court. State will recommend, will reduce count 1 to disorderly conduct under OCGA 16-11-39
Yes, ma'am.
and recommend a sentence of 12 months that you serve 2 months, which you've already got jail credit for, with the balance on probation. Special conditions are that you have no violent contact with Bryant Murray Sr.
Yes, ma'am.
and forfeit any seized property.
Yes, ma'am.
You understand that the court, oh, and state will not prosecute count 2. Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
You understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
You understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
You understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charge of disorderly conduct in indictment number 24 SC 001215?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you have only limited right to appeal this guilty plea conviction?
Yes, ma'am.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
You understand that you have only 12 months from today to do so?
Yes, ma'am.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about March 30th of 2022, this defendant, Bryant Murray Jr., did act in a violent or tumultuous manner towards Bryant Murray Sr., who is his father, which caused Mr. Murray Sr. to be in reasonable fear of life, limb, or his health. And that occurred in Fulton County. Judge, as I said, the victim is the defendant's father. There was an argument that occurred that resulted in this incident. So we've decided to resolve the case this way.
And your office has communicated with Mr. Murray Sr.?
Yes.
No pushback from him?
Correct.
Okay, got it. Thank you.
The defendant does have a prior first offender to a robbery. That conviction has been sealed already. It's from 2019, so I don't know much of anything about it other than it was first offender to robbery.
Okay. Ms. Simpson, is Mr. Murray still on probation for that? Okay, thank you. Ms. Jackson, do you have other criminal history information for Mr. Murray?
No, I just see the first offender that was in 2020. And they only listed the theft by receiving stolen property, and it says that it was sealed August the 9th, 2024.
Okay.
Probably,
probably got
I can't
reduced.
see what it was reduced
Right,
to.
right. Okay, great. Thank you. Ms. Cabrera.
Hey, yes, Judge. As she said, she's had an opportunity to speak with the father. Him and his father have a decent relationship. His mom is kind of the go-between for what that relationship looks like, but so far, so good. I am going to be asking that Your Honor accept the plea as negotiated. He does have a GED to complete. And then after that, whatever schooling it is needs to be done for videography.
Okay. Mr. Murray, how far along are you in your GED courses?
Practically, I'm at the stage where I can graduate. It's just the math giving me a hard time.
It's often the math. All right. Well, good luck with that. You working these days?
Not right now since my prior release, but I have been an entrepreneur. I'm a videographer.
Okay, that's what it sounds like. What will, if you get your GED, where do you go to school to do? Ms. Cabrera said then you'll go on to get a videographer.
So I know one of the schools I can look into would be Atlanta Technical College.
Okay.
That'd be one.
All right. Anything you want to share with me?
Not so far.
Okay. You and your dad on speaking terms?
We can be like, we'll communicate to my mom if there's anything.
She does the phone calls.
Yeah.
Okay. Do you stay with your mom?
No, I live, me and my girl, we have our own.
You get your own spot, and then when it's time to talk with dad, should you want to, that goes through mom?
Yes, Dad.
Okay, got it. Okay. All right, well, Mr. Murray, I find there's a factual basis for your plea. You and your dad got into something in March of almost 3 years ago. And your plea is knowing and voluntary. Voluntary means no one's forcing you to do this. Knowing means you've understood the things we talked about. You agree with that?
Yes, sir.
Ms. Cabrera, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
And Ms. Nix?
Yes, sir.
Mr. Murray, is it okay if we electronically sign your name on the indictment showing your plea to the one misdemeanor?
Yes, sir.
We'll do that. I will follow the negotiated resolution. Count 1 is reduced to disorderly conduct. I'm sentencing you to 12 months to serve 2 months. You'll get credit for the 62 days you've already done across your 2 jailings. So the balance will be on probation. That's 10 months of misdemeanor probation. 2 special conditions. 1, finish your GED. Gives you 10 months to figure out the math. You can do it 1 month per problem. And then number 2, no violent contact with your father. So if there were conditions of bond that said you guys can't be in the same place, those are gone. I'm not saying you need to be in the same place, but should you choose to, because there's a family get together, that's now okay, as long as it's a hands-off situation.
Okay.
Okay, and you decide whether that's smart and safe, and he decides whether that's smart and safe to be in the same place. That's what I've got. Misdemeanor probation is operated by a different group, so you're not gonna be getting reporting instructions from Ms. Simpson. What you're gonna get is a call or an email, maybe from Ms. Cabrera. It may be from the misdemeanor probation folks, but you'll need to respond to that. Don't ghost them, okay?
Okay.
All right, Ms. Cabrera, anything else on behalf of Mr. Murray?
I got one more thing.
Yes, sir.
So I just want to put it out there to you in case anything else happened. I keep getting my address changed, and for some reason it's not going through. So because yesterday I came up to the courthouse. If I wouldn't have came to the courthouse yesterday, I would have had a bench warrant today. So for some reason I'm not.
You didn't know you had court today?
No, I didn't know. I came up here yesterday just because God told me to come.
Yeah.
God told me to come.
So he called and he said, he was just like, he said, they told me I have court. I said, what's the address that they have for you?
So I've got.
And they wouldn't even tell him what the address was that they had for him.
What I've got is Lumbee Drive.
Is it 3051 Lumbee Drive?
Yeah, apartment 1023.
Yes, and it's nothing comes.
Okay, well, we also have postal service issues. There may well be in Palmetto, which is the big clearinghouse of all the mail, your magic letter. And so I'm glad God told you to come to court yesterday. You don't need to come to court anymore. It's going to be you and probation.
Okay.
And they're going to call you, they're going to email you, they're going to text you. They don't do a whole lot with the mail.
Okay.
So what you're going to need to do is give them all your contact information when you're told here's where to go or who to call. But that'll come from Ms. Cabrera. We'll probably have the misdemeanor probation people contact her, and she'll say, all right, Mr. Murray, you need to call this number sometime tomorrow. Just make sure you do it.
Yeah, so if you don't hear anything at all in the next 7 days, say so.
Okay.
Okay. You're always welcome to come down to court and ask. I'll let you know what's going on.
Okay.
Thank you for flagging that.
All right. Thank you.
Ms. Nix, anything else?
No, sir.
All right, that's it.
Thank you, Judge.
I bet. All right, let's get Ms. Carpenter back on the Zoom. Ms. Carpenter, can you turn on your stuff, please? You can come on up to the podium so she can see you.
Yes, Your Honor.
But I don't know if she stepped away from her phone. She's not
Hold on.
becoming active. Text her.
Text her. Sorry, Your Honor.
That's
One
all right.
second. I'll tell you.
She just dropped off. There's a Sheila Carpenter. I don't know if that, oh, now she got back on.
Yes, that's her mother.
There we
Yeah, I'm sorry.
That's okay, it's all good. Let me get you on the screen. There you are. Okay. And if you could slide over a little bit so you're on the camera, that way your client can see you. Perfect. So do we have an offer that's not being accepted? So I should get that on the record, or where are we?
So we received an offer yesterday, Your Honor, and we submitted a counter offer, and we are waiting for the state to kind of review some stuff that we sent over.
Okay.
It's possible it's going to resolve that way, but we would ask Your Honor just to preserve her final plea rights. The offer that we got yesterday is said to be open until February the 28th because it's coming from Ms. Nix, but I do understand, Your Honor, that you have a trial calendar on the 30th, so we can try to resolve it before then.
Judge, this case is not on the January 30th calendar. It's not until March.
Really?
Something.
I thought I may have misread it. I thought that Ms. Nelson had told me that everyone except for Honholt was on, but you know you've got the calendar. So it didn't make, maybe, okay.
This was a re-indictment, and so I think that this final plea was on the original indictment, but because I re-indicted it, it was, the trial was moved to March. I'm not sure, but at any rate, the date that is in the case is in March.
Okay. Yep. Look at that. Okay, my bad. No one needs to be here on the 30th of January. You're not on that calendar. There's nothing in here that says that. It's in March. That doesn't mean we can't try to work it out before then. Okay, so Ms. Carpenter, you're in a slightly different situation than most of the folks either on this call or in the courtroom, in that your trial date isn't for a couple months. sounds like the offer that the state made wasn't quite the right fit. So you and Ms. Calloway have counter offered and maybe provided some information to the state. So they're going to need to chew on that for a little bit. But because negotiations are still going, and it's not that someone has said no way, then I will preserve your final plea rights. And then I'm not going to see you for a couple months unless the case is worked out. And I just don't want you guys to forget about the case and not do anything with it. But that'll be the day. You're sort of on your trial calendar day is when you'd be working it out if something hasn't happened before then.
Yes, Your Honor. We'll work to get it
Do you have
done.
any questions, Ms. Carpenter, about what we discussed?
No, sir.
Okay, Ms. Calloway, anything else?
No, Your Honor.
Then we'll move this to the trial calendar, but preserve the final plea rights. Anything else, Ms. Nix?
No, sir.
You're gonna be long gone by then, so you will transition this to Ms. Dilligard.
Yes, I'll try to take care of it next week while we don't have court.
Fantastic. All right. You actually have 2 weeks with no court, so you should be able to take care of lots of things and be extra ready for the trial calendar. All right. Thank you, Ms. Carpenter. You are free to go, and thank you, Ms. Calloway.
Thank you, Your Honor.
Thank you.
That's
Bye-bye.
all I have, ma'am. Am I free to go?
Yes, ma'am.
Thank you.
Did you already send me? Oh, you were gonna send me.
All right, I got another hour 10 before we hit the break for our monthly bench meeting. Oh, you guys are here. Dennis Francis, Happy New Year.
Hey, Judge, Happy New Year. Good to see you.
Good to see you.
I have Cynthia Johnson.
You do, and Ms. Cabrera has Mr. Ross, and remind me of your last name. Ms. Vereen has Dominique Wright.
That's correct, Judge.
Are they all worked out?
We'll work out.
I'm not sure if Ms. Johnson's about to. Okay.
You need to chat with her. Okay, why don't you chat with her, and maybe that we can take a plea with all three.
Yes, you can, because I snuck out of Judge Cox.
Okay.
We have a immunity motion, which is next.
Uh-oh, so why don't you talk with Ms. Johnson?
Okay.
And if it's something we can do, we'll do it.
Yeah, I've already seen her, so.
Okay.
Sure.
Just when you ask the question, then you just say, Mr. Rock. Like that. And then, since it's the same box, basically, you just do one factual basis.
This is one of those no lunch days.
Mr. Kraft, do you have an update? You still talking with the prosecutor?
Judge, I think we, if we could approach on the Hammond case, or do we need to approach? I don't know.
I don't think we need to approach.
Okay.
If you wanna do that at the same time, we can do both Hammonds.
As in, it's working out, or it's not working out? Final plea hearing. We'll do them at the same time, but we'll do, so if this situation, why don't we can do that right now?
I think the only thing, Mr. Kraft's referring to is we might need to do a bond modification though,
Okay,
for the address.
got it.
Yes.
Okay. First, let's see what Mr.
Yes.
Ready to go? Okay, we'll get her out in just a minute. Bond modification in terms of letting someone reside somewhere else?
I think they're living with separate family members and they might be switched.
Okay.
That's correct.
Okay. Well, why don't we do the final plea hearing for our Mr. Hammond and Mr. Hammond brothers?
Yes.
The brothers Hammond, okay? So why don't we have Jaquavius Hammond and Mr. Kraft at the podium, and then Quantavius Hammond, you can sit with Ms. Wood at the council table. And Ms. Nix or Ms. Dilligard, who's handling the Hammonds?
That'd be me, Judge.
Okay, well, let's get on the record in 24 SC 003942. It's State versus Jaquavius Hammond, represented by Mr. Kraft. They're standing up at the podium. And Quantavius Hammond, represented by Ms. Wood, and they are seated at defense counsel table. Gentlemen, you're both charged with armed robbery and carjacking, couple other offenses. And today is, in theory, the last day to enter a plea, if you were going to plead, where you could withdraw the plea if you didn't like the sentence that I gave you. You are charged with some things that have some pretty serious mandatory minimums. And so that doesn't give me a lot of flexibility to do things all that different from what might be recommended if I thought I needed to do something different, depending on what the recommendation is. But let's hear from Ms. Dilligard what the recommendation is, should either Mr. Hammond want to enter a plea today.
Judge, the state's recommendation is 15 to do 7 pursuant to OCGA 1710 6.1E.
15 serve 7, and I'd structure it however, but that would resolve all the counts.
All the counts.
Okay, all right. So Jaquavius Hammond, do you understand what the state's recommendation is? If you were to enter a plea today, the state would be recommending a term where you'd serve 7 years in custody, followed by 8 years on probation. Do you understand that?
Yes, sir.
Okay. And Quantavius Hammond, same recommendation. If you were to enter a plea today, the state would be recommending that I sentence you to 7 years in custody, followed by 8 years on probation. Do you understand that? Okay. Jaquavius Hammond, is that an offer you're interested in pursuing today?
Judge, I think what we want to do, if I want to make a request to hold open his final plea rights. As I discussed earlier, we have some outstanding subpoenas that we haven't received the information back on. I do want to see what those are going to say, and I want to have an opportunity to have further discussions with Ms. Dilligard on the matter.
Okay. I don't want you to reveal secret defense strategies, but what's the general nature of what you're trying to subpoena?
The subpoenas are phone records from my client and the alleged victim, and likely in Instagram records and possibly Cash App records. So I just want to be in full disclosure. I filed phone subpoenas for phone records back in November, based on information that I received from my client's family yesterday. I think we might be submitting subpoenas for Cash App records and Instagram records.
Okay, so you haven't done those yet.
Haven't done those yet, but the phone records are requested.
And you haven't heard back from the phone companies yet?
One is T-Mobile and the other is Verizon, and I haven't heard back.
Okay. You haven't been told we don't have anything. You haven't been told we've got something, but it's taken a while. You've heard.
There was my investigator originally subpoenaed the wrong company, so I obviously received a response there, and then another one was filed for Verizon. So I haven't heard back, and I have not heard back from the T-Mobile subpoena that we sent out in November.
Okay. All right. So you want the final plea rights preserved because there could be information you're able to provide that could shift things in your client's favor.
That would be my guess. Yes, Judge, I think so.
Okay. Your client and his brother are on the January 30th trial calendar.
Yes, sir.
I don't know that you're going to have Instagram or Cash App information back by then. And if you did, it might be coming in right on the eve of trial, in which case Ms. Dilligard might say, I need some time. So I guess we'll need to see how that plays out.
Yes, Your Honor.
I guess what I'm going to ask you to do is, I know I will see everyone again on the 30th when we call the calendar. You're going to need to have information from each of the recipients of subpoenas. Yes, we're getting you something. Here's why it's taken so long. Phone companies, Cash App and Instagram received, but we always require 60 days. Something where you can share with me, not a hunch, but I'm being told that we will get something, whatever that something is. And it could be a letter that says we have nothing responsive to your subpoena. What I don't want to do is be in this endless holding pattern where your client's out on bond and we can't move forward because there's this mythical, maybe I'll get something from Verizon situation.
Well, I'll work to get updates, Your Honor.
Okay, that's all it is updates. And so hopefully your investigator can extract that.
Your Honor, and the other matter is kind of a joint matter with Jaquavius and Quantavius. No, this one. Their original bond order had one of them living with their father and one of them living with the mother. The family has inquired about switching so they could spend time with the other parent. So I was going to file a bond motion, but I believe the PUD's office thinks that we might be able to handle that this morning if the courts want.
Trying to find the bond order. Here it is. So Jaquavius, your client, is required to reside with his mother.
Yes, Your Honor.
And you are asking, could it swap so that actually Quantavius resides with, is it pronounced Juhan? Juhan, that Quantavius would live with Ms. Juhan and Jaquavius would live with, I just don't have the other bond up, but the father.
Yes.
Okay. I don't have an issue with that as long as both defendants want that. But I do need to hear from Ms. Wood and Ms. Dilligard. Ms. Dilligard, do you have any concern as long as we've got a fixed address, we're just swapping? So it's not, you guys can live in the same place, but on date X, you're gonna change houses.
No issue, Judge.
Okay, all right, got that. You guys stay put right there. Ms. Wood, same set of inquiries. It sounds like, well, let me start with you, Quantavius Hammond. Are you interested in pursuing that offer from the state, 7 years to serve, followed by 8 years in custody?
No, Your Honor.
He's not, okay. Any discovery issues on your side? And I didn't hear Mr. Kraft say anything about, I don't have X from the state. He's trying to get things not in the state's custody.
I think I have everything that the state has. I did send Ms. Dilligard an email and we'll talk just to inquire about some potential medical records that might exist, but otherwise I think I have everything.
Okay. Medical records for no one got shot.
Right.
Okay.
Yes.
Okay.
For the victim.
Okay. All right. Understood. So you're good to go. We don't really need to preserve final plea rights for Quantavius Hammond. He's saying no thank you to 15 to do 7, and you're ready to move forward with the case.
Yes.
Okay. Quantavius Hammond, are you interested in changing houses so that you would move from your father's house to your mother's house, and that would be the place you need to stay?
Yes.
Okay, we can make that happen. Ms. Dilligard, anything from the state?
Nothing from the state. I did reach out to the victim regarding the medical records. I'm waiting to hear back to see if she did seek medical treatment. I'm not in possession of any medical records, but I can look into the matter.
Well, just so everyone is managing expectations, you don't have any greater access to medical records than the defense does in terms of getting an order from me or whatnot. Certainly, if Ms. Jackson is willing to sign a release or something, that can expedite things, and you're in a better position to talk to her about that. But I don't want Quantavius Hammond to be thinking, the state's not handing something over. If you never asked for them, then you don't have them, and they're not in GBI possession. They'd be at Grady or Piedmont or wherever Ms. Jackson went, if she went anywhere. Okay, got it. Mr. Kraft, anything else on behalf of Jaquavius Hammond?
No, Your Honor.
And Ms. Wood, anything else on behalf of Quantavius Hammond?
No, Your Honor, thank you.
So I will see everyone on January 30th. I'm gonna keep this as a let's get ready for trial situation. I'm on notice that there may be some outstanding discovery that Mr. Kraft is seeking, and we'll see if that's a reason to delay the trial or not. We'll have that conversation, but I'm definitely on notice. I will modify the 2 bonds so that the young man can switch houses. I will keep open Jaquavius Hammond's final plea rights, and we'll see what happens on the 30th. Okay.
Thank you.
Thank you. You are free to go.
We can talk outside. I'm gonna talk to her. Okay.
So if we could do the 3-person plea now, did we lose Mr. Francis?
We did, but he spoke to her and asked if she was comfortable with me standing in to do the plea. There, nothing is adverse to either one of them.
Sure. If she
yeah,
says on the record, no problem, let's do it.
She told them that she was fine. They had the same recommendation.
Okay, great.
So I can do both.
All right. Then you tell me, Deputy Gordon, how you want to structure it. It's 3 inmates. Do we need to bring in 8 more deputies, or are we gonna be all right? We got some big guys. The table, okay, great. We'll have people seated.
10-11.
So Ms. Vereen, we're ready to go. Ms. Dilligard, are you doing the plea or is Ms. Nix?
That'll be me, Judge.
Okay, and so you're gonna do exactly what you did before. Your question will be, do you waive your right to a trial, whatever your question is, and then you will say, Ms. right name, you'll say, Mr. Ross. Yes, I do. Ms. Johnson. So you just ask, you don't have to repeat the question 3 times.
Okay.
You will say, do you waive your rights? Mr. Ross. Yes, I do. Ms. Johnson. Yes, I do. Mr. Wright. Yes, I do. Okay, so one factual basis, you say your question once, and then just make sure, we're gonna agree up front the order in which you're gonna do it, so that, meaning of the defendants, so, Ms. Rivers knows what the flow is gonna be, okay?
So they're gonna sit and. Okay, I got you.
Or should,
It don't
You-
matter.
you
I'm just
have-
standing in the middle of the ward.
If you did it, I'll take it. Thank you.
Because he wants to make sure at the conclusion of this, he gets released, so I was like.
Got it.
and then,
Make it official.
just say, I mean, you can do it every way, but, disorderly is, or torturous manner such that the victim is placed in full fear of a,
Is your case ready to go?
injury to
They
their
were gonna
life,
have a
limb, or
discussion amongst themselves before they gave.
Oh, the 2 prosecutors.
This next.
Okay, all right.
Judge, thank you.
Yeah, I'm just standing between tables.
the safety of their life, limb, or health. That's the language. Is that her right there?
Just thinking about where microphones are and all that.
I'll come closer. And Karen is not anywhere.
No, she's virtual, which is why I just need folks near microphones. All right, so you're Mr. Ross?
Yes, sir.
Good morning, Mr. Ross. Ms. Johnson, you're seated in the back there, is that right?
Yes.
All right, good morning. And that means you're Mr. Wright.
Yes, sir.
Okay, good morning, everyone. I'm Judge McBurney. Some of us have met before, some of us may not have met. But I have been told by Ms. Cabrera, who is Mr. Ross's lawyer, by Mr. Francis, who is your lawyer, Ms. Johnson, I'm gonna talk about that in a minute, and then by Ms. Vereen, who is your lawyer, Mr. Wright, that the 3 of you are prepared to enter a plea in your case. Is that correct, Mr. Ross?
Yes, sir.
Is that correct, Ms. Johnson?
Yes, sir.
And is that correct, Mr. Wright?
Yes, sir.
All right. Well, I'm gonna get on the record then, so we can make a record of all this. This is 24 SC 004077. And the first thing I want to do is start with Ms. Johnson. Your lawyer is Mr. Francis. He is a close colleague of Ms. Cabrera, and he explained to me, because he's got to be in another courtroom right now, that you are comfortable having Ms. Cabrera answer any questions you might have during the conversation we're going to have as a group. Is that correct? Okay, so you're comfortable moving forward just with this conversation, having Ms. Cabrera be your lawyer as well. Okay, and Mr. Ross, you have no concern with that?
No,
sir.
Great, all right. Then here's how this is gonna work. In a moment, Ms. Dilligard, who's seated up here in front of you all, is gonna swear you in, and she's gonna ask you a bunch of questions. She'll state each question once, like state your name, and then she'll say, Mr. Ross, Ms. Johnson, and Mr. Wright. So you're each gonna be answering the same questions, but that way we can handle this all at once. It'll go faster for you, and you'll know the outcome much sooner. Mr. Ross, do you have any questions about the process?
No, sir.
Okay. Ms. Johnson, any questions about the process? Mr. Wright?
No, sir.
If at any point someone says something that doesn't make sense, or you can't hear, or you've got a question about what's going on, will you please let me know, Mr. Ross?
Yes, sir.
Ms. Johnson?
Yes.
Mr. Wright?
Yes, sir.
That's what we're gonna do. When you're ready, Ms. Dilligard.
Can you all please raise your right hand to the best of your ability? Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am. Yes, ma'am.
Yes.
Please state your true, correct, and legal name, Mr. Wright.
You all can put your hands down. All right. And we're gonna go Ross, Johnson, Wright, if that's okay.
Please state your true and correct legal name. Start with Ross.
Michael Ronaldo Ross.
Johnson.
Cynthia Johnson.
And Wright.
Emily Daniel Wright.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol, Mr. Ross?
No, ma'am.
Ms. Johnson.
No, ma'am.
Mr. Wright.
No, ma'am.
How old are you, Mr. Ross?
21 years old.
Johnson.
58.
Mr. Wright.
51.
How far have you gone in school?
All the way to 12th grade.
Say that again?
All the way to 12th grade.
You graduated high school?
Yes, sir.
10th.
8th.
Is English your dominant language?
Yes, ma'am.
Ms. Johnson?
I didn't hear what you said.
Is English your primary language?
Yeah, yes.
Do you understand that you have been charged with the following offenses? Count 1, aggravated assault, and count 2, reckless conduct, Mr. Ross?
Yes, ma'am.
Ms. Johnson?
Yes, ma'am.
Mr. Wright?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Have you had an opportunity to review the waiver or rights form with your attorney?
Well, hold on one second. You mind closing that? They're having like an assembly out there.
Please don't rattle the chains.
Oh, all right. Okay.
Have you had the opportunity to review the waiver of rights form with your attorney, Mr. Ross?
Yes, ma'am.
Johnson?
Yes, ma'am.
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the charges in this indictment, including the facts and circumstances related to these charges?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Would you like any more time to discuss this case with your lawyer?
No, ma'am.
No, ma'am.
No, ma'am.
Are you satisfied with your lawyer services?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Counsel, do you waive formal reading of the indictment for purposes of this plea?
So waived for Mr. Ross and so waived for Ms. Johnson. Same announcement, so waived for Mr. Wright.
And do you both counsel waive all and any defects in the indictment for purposes of the plea?
Also waived for Mr. Ross and Ms. Johnson. Also waived for Mr. Wright.
Do you remember being arrested for these charges, Mr. Ross?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to? For the aggravated assault, it's 1 to 20, and for the reckless conduct, it's 12 months.
Yes.
No, ma'am.
Can you repeat the question?
has their attorney advised them of the
Oh,
minimum
right, the
maximum.
okay, I'll advise you all. I just want to make sure you understand, count one, aggravated assault, the sentencing range is 1 year to 20 years. And the sentencing range for reckless conduct, which is a misdemeanor, is 1 day to 12 months. So 1 to 20 years for aggravated assault, 1 day to 12 months for reckless conduct. Do you understand that, Mr. Ross?
Yes, sir.
Okay, Ms. Johnson?
Yes.
And Mr. Wright?
Yes, sir.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, for defendant Ross and for defendant Johnson, the recommendation is 18 months, 18 to serve 6 months.
18 months to serve 6 months.
Yes, Judge.
Are the aggravated assaults being reduced to a misdemeanor?
Yes, my
Okay.
apologies. They're being reduced to disorderly conduct pursuant to OCGA 161139.
And that's Ross and Johnson.
Correct.
Okay.
And that is also with 100 hours of community service.
Okay.
And for defendant Wright, the recommendation is 8 years to do 6 months. That one's probated with 150 hours of community service is what the state is recommending.
Okay.
Do you understand that, Mr. Ross?
Yes, ma'am.
Ms. Johnson and Mr. Wright?
Yes, ma'am.
You understand that the court is not required to accept the state's recommended sentence? Mr. Ross?
Yes, ma'am.
Ms. Johnson? Mr. Wright?
Yes, ma'am.
You understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Yes, ma'am.
Yes, ma'am.
Do you understand that, do you understand that the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Are you on probation anywhere?
No, ma'am.
No, ma'am.
No, ma'am.
Judge, Mr. Wright currently has 2 VOP warrants for 2 Fulton County cases.
Okay.
They're pending.
Pending as in they haven't been signed yet?
Yes, Your Honor, they haven't been signed, but it is for this arrest.
Okay.
And failing to report and failing to pay restitution.
Okay. Do you have those case numbers?
Oh, yes, Your Honor.
The first one is 22 SC 182467.
Okay.
And the second one is 23 SC 187964.
Okay. Thank you. Mr. Wright, we're going to talk about it. Don't panic. But it's good to know that that's out there. All right. Thank you for flagging that. Okay. Back to you, Ms. Dilligard.
Do you understand that if you are currently on probation or parole, your probation and parole may be revoked based on your entering of a guilty plea today?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
You understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
You understand if you're on probation, you must follow all the special, oh, I was only.
Can I get responses from the other 2 defendants, please?
Yeah, we had a pause. Mr. Wright was asking his lawyer a question. So let's rewind. And if you'll ask that same question again, please.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Make sure you guys speak in.
Yes, ma'am.
You understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
You understand that if you fail to follow any of the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
US citizen?
Yes, ma'am.
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am. My bad. I'm sorry.
All right.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
No, ma'am.
No, ma'am.
Is it your decision to enter a guilty plea because you're in fact guilty?
You want to talk with Ms. Cabrera for a second?
Yes to the conduct, but not to the,
No, just a second.
oh, yes, sorry about that.
That's okay.
Ms. Johnson?
I'm feeling the same way. To my reduced charges, ma'am.
Okay, Mr. Wright.
And Your Honor, I would like to seek probation as well before,
You'd like to pardon me?
I'd like to seek probation before, the plea concludes.
You'd like to speak with probation?
Probation, yes, because I wasn't aware of the, two BOP warrants in this jurisdiction, so.
Okay, well, it doesn't sound like they're signed yet, so I don't know that there's anything technically holding him, but I'm gonna look up those cases.
Okay, so at the conclusion of this plea.
Yeah.
More than likely.
We'll talk about it. Okay, but the question is now on the table, Mr. Wright, are you pleading guilty to these charges?
Yes, sir.
Okay, thank you.
Okay, Mr. Ross, how do you plead to the charges of aggravated assault? Oh, or no, you're pleading guilty to disorderly conduct and reckless conduct.
Yes, ma'am.
How do you plead in regards to that manner in indictment number 24 SC 004077?
Guilty.
Speak up.
Guilty.
And Ms. Johnson, how do you plead to the charges of disorderly conduct and reckless conduct in indictment number 24 SC 004077?
Guilty.
And Mr. Wright, how do you plead to the charges of aggravated assault and reckless conduct in indictment number 24 SC 004077?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Hold on, let's do two things. One, gotta make sure we go in order, but I want the record to reflect, since Ms. Rivers couldn't see this happen, that Mr. Francis has returned, so that while Ms. Cabrera has been acting with Ms. Johnson's permission and Mr. Francis's knowledge as Ms. Johnson's counsel, her actual appointed counsel is back in court and will resume those responsibilities. So the question was, do you understand, three defendants, that you have only a limited right to appeal your conviction if you enter a guilty plea? Mr. Ross?
Yes, sir.
Ms. Johnson?
Yes, sir.
And Mr. Wright?
Yes, sir.
Okay.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, Mr. Ross?
Yes, ma'am.
Johnson?
Yes, ma'am.
Right.
Yes, sir. I mean, yes, ma'am. I'm sorry.
Didn't mean to switch up on you. It'll be ma'am from here on out.
Do you understand that a felony charge, you only have 4 years from today to file a habeas corpus petition, Mr. Ross?
Yes, ma'am.
Ms. Johnson?
Yes, ma'am.
Right.
Yes, ma'am.
In their case, it's gonna be a year, because it's a misdemeanor.
Right.
Yes.
Yeah.
So I want to make sure, I'll just state that again. Do you understand that for the misdemeanor charges, you only have 12 months from today to file a habeas corpus?
Yes, ma'am.
And Ms. Johnson?
Yes, ma'am.
Judge, if this case were to proceed to trial, the state would be proving that on June 14th, 2024, APD was dispatched to 25 Peachtree Street Southeast in reference to a person stabbed. Officers were met by the victim, which is Mr. Reginald Walls. He was stabbed by the defendant, Mr. Wright. Johnson stated to officers that Walls had stolen her Bluetooth speaker 2 days ago and that she was attempting to retrieve her property along with Mr. Ross and Mr. Wright. They approached the victim. They took a knife from him. Wright then lunges at the victim and strikes him with that knife. As Walls is being stabbed, he continues to hold on to his backpack during the attack and refuses to release it. He falls to the ground. He's struck in his arm, his hand, and while he's on the ground, the defendants appear to throw a water jug at him. Officers were able to locate surveillance, but we were not able to retrieve that from APD, unfortunately. The reason for the reduction in regards to Mr. Ross and Ms. Johnson is because they did not have the knife. They did not stab the victim, unlike defendant Mr. Wright. And all of this did occur in Fulton County, Georgia.
Okay. Any success in tracking down Mr. Walls?
We've tried multiple, let me make sure this is the right one. Actually, we did try to contact the victim, but my investigator was actually made aware yesterday that the victim is actually deceased. And so we've requested a death certificate and we're pending that at this moment.
Okay, got it. Thank you. Let me hear from Ms. Jackson. Any criminal history information on Mr. Ross?
Mr. Ross have 2 cycles. The last arrest was September the 11th, 2024 with the city of Atlanta for 2 counts of theft by receiving stolen property. There was no disposition for that arrest. There are no convictions.
Thank you. And for Ms. Johnson?
She has 4 cycles. The last arrest was July the 2nd, 2018 out of South Carolina for drinking alcohol in a public place. There was a non-conviction for her. That date was August the 1st, 2018.
And finally, Mr. Wright.
Mr. Wright has 78 cycles. The last arrest was March the 21st, 2023 in Fulton County for unlawful to knowingly remove / destroy. There's no destroy, circumvent operation. So felony, there was no disposition for it. And also he has a charge of a failure to appear. The underlying charge was not listed. He does appear to be on probation for felony obstruction. That case number is 23 SC 187964. That disposition date was August the 23rd, 2023, and the term is for 4 years. He does have prior felony convictions. One in 2011 out of Gwinnett County for forgery in the first degree. One in 2009 out of Gwinnett County for forgery in the first degree. One in 2003 for aggravated assault and robbery. One in 2001 for possession of marijuana with the intent to distribute. One in 1997 out of DeKalb County for forgery in the first degree. And he does have prior misdemeanor convictions. One in 2022 out of DeKalb County for theft by taking and obstruction of an officer. One in 2019 out of Shamley, Georgia for theft by shoplifting. He received a nolo contendere sentence in 2019 for theft by shoplifting. And there was a conviction in 2019 out of Dunwoody, Georgia for theft by shoplifting. There's one in 2014 out of Harris County, Georgia for simple battery. There's one in 2000 for battery, family violence. Nothing in addition, Your Honor.
Thank you, appreciate it. Okay, let's start with Mr. Ross. Ms. Cabrera, I have found that he has another open case. So what we're doing today is resolving this one. I think he has a bond on the other case. It was
He
with,
does, he just hasn't, his mother hasn't paid it yet.
right, because he's stuck on this,
Right.
but we'll be back together at some point. I don't know, are you his lawyer on the other
I
case?
haven't got it. Doesn't mean it won't happen,
Okay.
just hasn't yet.
It is a,
What's the number on it?
I'm gonna pull it up in just a second. It is 24 SC 005867. And someone named Aaron Jenkins is the name listed, but that may have been from Judge Schwall's courtroom. I don't know that person. Did you hire someone in that case, Mr. Ross? No, it's the theft by receiving that we heard about from
So it got transferred from,
Judge Schwall.
okay. She said city of, the arrest was in city of Atlanta, or was it a city of Atlanta case?
We look.
I got the impression it was a city of Atlanta case, because as far as he knows, it's a misdemeanor.
It's APD and it may have been upgraded because it is burglary of the dwelling house of Ms. Smith. And then theft by receiving a Toyota Sienna and some financial transaction card stuff. But there are two co-defendants. There's a Mr. Martin and a Ms. Bernard. So it's a three-person case again. Anyway, it's with me now. We're not resolving it today. I just didn't want Mr. Ross to be surprised, like, wait, why am I back in court? If he's got bond, then, or if he can post that bond, that won't be.
He said it was
anything.
something as low as like $1,000?
There was a consent bond entered in October. It is $1,000. It was before it was indicted. So I don't know how that'll play out if he tries to post it because the indictment has new charges.
Okay, well, I guess as soon as he can be on the calendar before,
We'll work
Your
through it.
Honor, then we'll deal with that.
Okay.
I'm pretty sure it'll come my way, just hasn't yet.
It's on plea and arraignment in just a few weeks.
What's the date on that?
The 27th of February, so a
Okay.
little more than a few weeks.
Okay.
Um,
Thank you, Judge.
Yep, and we'll learn who the lawyers are. Okay. Mr. Ross, do you have any questions about anything we talked about, other than your new case? I don't want you to worry about the new case. This case, no questions?
No, sir.
Okay. Do you have a place to stay when you get out?
Yes.
And where is that? I don't need street address, but is it with family or friends?
Oh, family.
Okay, all right. Ms. Johnson, do you have any questions about anything we talked about?
No, sir.
All right, did you used to be in South Carolina?
Yes.
Okay, what brought you to Georgia?
I used to live in Georgia, then I moved to South Carolina, then I came back.
Now you're back, okay. Do you have a place to stay when you get out? No, okay. All right, and Mr. Wright, any questions about what we talked about?
I just want to know about the probation.
So I looked up one of the cases, the one that Ms. Jackson mentioned, the 23 SC case. That was a case in front of Judge Dunaway, and you were sentenced to RSAT through Department of Community Supervision. Did you go do RSAT?
They didn't send me the RSAT, they let me go from jail. They let me go from here and told me to go report to probation. And I was reporting to probation before I caught this case. I was going to probation over there up in right there by the driver license place.
Yeah, Memorial, it's not far from here.
Yes, sir.
Okay,
And
all right.
I was paying my money. So
Okay.
I know only way I caught there is this charge here. But
Well, and that would be, I think, what the issue is with probation in those other cases. Do you have any information about RSAT happening, not happening?
they didn't come get me.
Give me
They
one moment, I can-
Okay, you can look that
I
up.
can let you know about
Okay.
They let me go from here.
It's not on you. I mean, the way I understood Judge Dunaway's sentence, you were supposed to stay in custody until you went to RSAT, but something could have changed.
They let me go.
Well, that would be something that
Let me go.
changed. Okay, I don't think you escaped. All right.
Yeah, I don't see that he completed it and or entered
Okay, but if he never entered it, then he couldn't complete it. All right, we'll work through that on another day. For the three of you, I find there's a factual basis for each of your pleas. It sounds like you had different connections to what happened with Mr. Walls. And I find that for each of you, your pleas are knowing and voluntary. Knowing means you've understood what we talked about. And if you didn't, you asked, and you guys asked good questions. Voluntary just means no one's forcing you to enter these pleas. Mr. Ross, is it okay if someone in my office signs your name on the indictment indicating your plea? There's going to be an electronic signature. It'll just say Mr. Ross pled guilty.
Yes, sir.
That's okay. Ms. Johnson, can we sign your name as well?
Yes, sir.
And Mr. Wright, okay if we electronically put your name on there?
Yes, sir.
Ms. Cabrera?
Yes, Your Honor.
Mr. Francis?
Yes, sir.
Ms. Vereen?
That is, yes, Your Honor, that's fine.
Okay, and Ms. Dilligard?
Yes, Judge.
We'll take care of that. Mr. Ross, I'm going to follow the recommendation here, although, a little time out, the math I've done, Mr. Ross only did about,
4 months.
if you add the two cases together, but it's 121 days on the other case that's open. It's 29 days on this one.
He knows he's not going anywhere right this.
Okay, as long as he knows
Yeah,
that.
he knows that, and I gave Ms. Delgard my card so we can try to figure out if it's possible to reach a resolution before the arraignment calendar.
Excellent. Highly likely. Yes, ma'am.
And Your Honor, just to touch back on that, Arset, at the time, the defendant actually had pending charges, and so he wasn't able
to go. Okay. Understood. All right. So then I'll follow the recommendation. I just want to make sure because Ms. Johnson has spent a whole lot more time in custody. And so it's just a slightly different outcome. Same sentence. Mr. Ross, on count one, I am sentencing you to 6 months to serve. That's the disorderly conduct, followed by 12 months probation on count two. That's the reckless conduct, for a total sentence of exactly what your lawyer said you'd get. 18 months to serve 6 months with the balance probated. And you will get credit. I don't know that you're going to get credit for all the time you've been in because you've actually been in on 2 different cases. But one of the things Ms. Cabrera is trying to do is, and work out that other case as well, then you can mush it all together. But for this case, you'll certainly get credit for the month you were in before you bonded out and then got picked up on those other charges. When you do get out, you will be on probation for 12 months. As I said, I will waive the supervision fees for the first 3 months while you get on your feet, hopefully get some work going, and you will need to do 100 hours of community service. Any questions about any of that?
No, sir, I'm willing to follow every rule and commandment.
Okay, I don't issue commandments, but I did issue a sentence. All right, Ms. Johnson.
Yes.
I am going to sentence you to 6 months to serve on count one, which has been reduced to disorderly conduct, followed by 12 months probation on count two, that's the reckless conduct, so 18 months to serve 6. You'll get credit for the 209 days you've been in custody. That's more than 6 months, so you ought to get out tomorrow. Tomorrow's gonna be a strange day in Atlanta, so if you don't get released, it's not because anyone forgot about you, it's because there's snow on the ground and that kind of shuts stuff down. If you're still in jail next week, you call Mr. Francis, he'll bug me, and we'll figure out what the holdup is, okay? Excellent, good, he'll do that. You will also have 100 hours of community service. If you need to plug in with probation, I'm gonna waive your supervision fees for the first 6 months while you figure out a stable place to be, okay? All right, Mr. Wright, count one, I am sentencing you to 8 years to serve 6 months with the balance on probation. Count two is 6 months to serve. That'll run concurrently at the same time. So it's a total of 8 years to serve 6 months, balance probated, and then you'll be on probation. I'm going to waive your supervision fees for the first 3 months when you do get out. And then you're going to need to do, I know the request was 150, but I'm going to have it at 100 hours community service as well. When you are out, I'm going to hold off on signing your final disposition because we need to sort out this probation piece. We don't need to do that right this moment. I want to let some other people go, but I need to make sure probation has a chance to do what they need to do in connection with probation. And it may be that we talk about that as a threesome as well, okay? Do you, Mr. Ross, have questions about your situation?
Other than that, well, I'll be doing my 6 months after starting today.
You receive credit for time served, so your 6 months has already started. The question is when that's gonna actually resolve, and we're gonna work on trying to resolve your other case. And
But
then-
you get credit from today. You get credit for the 29 days for sure,
Yeah.
and your clock is running.
Okay.
So if I don't see you again, I'm making this up, for 3 weeks, you'll have done 3 more weeks on this sentence. And then we'll be figuring out, what are we doing with this case with the burglary and the stolen Sienna? Okay. All right, Ms. Johnson, any questions? Okay, Mr. Wright, other than about your probation, any questions?
No, sir.
All right, then what I'm gonna have you do is go back there, all 3 defendants go back there. Ms. Vereen, if you'll just sit tight, we're gonna sort out, we don't need to give reporting instructions to Ross or Johnson. We're gonna hold off on Mr. Wright, because we need to work through a little bit of probation, okay? We'll bring you back out here.
Thank you.
All right, yes?
Can you, I'm sorry, can you repeat Mr. Ross?
I'll give you my mama number.
Okay.
Yeah, just a sec.
389 0171.
What's her name?
Miss Linda. LIN DL.
Okay, what I'll do is I'll get an email address from her.
Okay.
Because once we get all of this worked out, you're gonna be able, you're gonna have to report to misdemeanor probation, so I gotta send you
Okay.
information for that.
Got it. And this is a routine?
Yeah, but she was born to have a little heart murmur, so they're just making sure that it was.
Good,
Yeah.
okay, good luck. I'm glad it wasn't tomorrow, because it's not gonna happen tomorrow.
Yeah.
Do you need to head out to the doctor now?
Thanks for your accommodation, Judge.
You bet.
You're doing stuff upstairs.
Okay. I'm here all day.
I heard you had 8 or 9 folks in California. Such is life.
And I talked to her.
Take care. All right, we can squeeze in one more plea before we have to break for lunch, if there's anything that's ready. I know there are people online and people in here, so I don't know how you want to do that. And then we will do all the others that are here. People can go have lunch after that, because I have to go to this bench meeting.
I would like to do my plea because she has a child that she has to get pretty soon. Mr. Frederick.
Mine is just an announcement, Judge.
Then we'll do both. We'll do your announcement and then we'll do the plea. And your client is?
Frederick, I'm sorry, I forgot her first name, Miss Frederick.
All right, why don't you come on up? And your case is, remind me.
Robert Phillips.
Right, you are filling in for Mr. Smith, and Mr. Phillips is here?
He is here.
Okay, Ms. Nix, are you handling that?
I can, yes, sir.
Okay, Mr. Phillips, just come on up and stand with your lawyer so we can all see and hear each other. All right, so you all weren't able to sort something out?
It's
Carolyn.
So
Okay.
Judge, where we are right now is the state made an offer. The defendant is interested in drug court. The state's not agreeing to drug court, but if the defendant pleads, then Your Honor can send him to drug court if he is accepted. So I've sent a accountability court application to defense counsel to fill that out. I think what we'll do today is preserve final plea rights until the trial calendar. And the state's reducing, this is a trafficking, the state's gonna reduce it to possession with intent.
Okay.
And we might end up doing a non-negotiated plea once we have an idea about where drug court is.
That all makes sense. So Ms. Goldstein, Steen or Stern? Steen, I have bad handwriting. Ms. Goldstein, you will then need to make sure you can extract from the accountability court folks an answer as to whether Mr. Phillips would be accepted. They're pretty quick with the turnaround, so you, pardon me? By the 30th, right, because we will all be together again on January 30th, at which time maybe we're taking a non-negotiated plea. I'll preserve the final plea rights, so Mr. Phillips can withdraw his plea if he wants to, and we've got a trial calendar and folks need to be ready to go on that. But it is important to have, as part of the plea conversation, that nugget of information of yes, drug court is a possibility, or no, they don't view him as someone who is high risk, high needs. He might be someone who is a problem for all the people in drug court. They'll make that assessment. So just do make sure the two of you follow up with the intake team, make yourself available to them so that they can provide that info of yes, if you send him, judge, we'll take him. Okay?
Understood.
All right, so final plea rights are preserved. We don't need to go over any of that other stuff, and we'll see everyone at the latest on the 30th. If you all come up with something and want to do it before the 30th, that's fine. Although it's a weird couple, next week I'm available, I'll be doing civil stuff. The week after is judges conference, so then we get into the week of the 30th anyway. All right?
Understood, Judge.
Mr. Phillips, any questions about that? Okay, we'll see you guys then. Thanks for your patience.
Thank you.
You are Carolyn Frederick, yes?
Yes.
All right, position 11, Ms. Rios, and one more from Ms. Dilligard, or?
Yes.
You're gonna do this one, all right. Ms. Vereen, I'm not forgetting about you. I don't know that we're gonna be able to do a whole lot before the lunch break, but I just wanna touch base. All right, this is position 11, 24 SC 003925, State versus Carolyn Frederick. She's here in court with her lawyer, Ms. Rios, and we have Ms. Dilligard from the state. We've watched a few of these pleas now, so you know the mechanics. You're gonna get sworn in, and then you'll need to answer some questions. And you let me know if you've got any questions of your own, okay?
Okay.
All right, Ms. Rios, Ms. Dilligard.
And please raise your right hand. Do you swear or affirm that any statement or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth?
Yes.
Please state your true, correct, and legal name.
Caroline Frederick.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
How old are you?
34.
How far have you gone in school?
High school.
Is English your native language?
Yes.
Do you understand that you have been charged with the following offense, one count of aggravated assault?
Yes.
Do you understand that you had the right to plead guilty or not guilty to that charge?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had the opportunity to review the waiver of rights form with your attorney?
Yes.
Have you had enough time to speak with your lawyer about all of the charges this charge, one charge in this matter, in the indictment, including the facts and circumstances related to the charge?
Yes.
Would you like any more time to discuss this case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive formal reading of the indictment?
Yes.
Do you waive any and all the facts in the indictment?
Yes.
Ms. Frederick, do you remember being arrested for these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for this charge that you're pleading guilty today, the minimum being 1 year and the maximum being 20 years?
Yes.
You understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court: 10 years, a stay away from the incident location, no violent contact with Wilfredo Munez, an anger management course within 6 months, 150 hours of community service.
Yes.
Can you say that one more time? I was having to deal with something on the screen.
No problem, Judge. It's 10 years probation.
10P, okay.
Yep, a stay away from the incident location, which is 5405 West Hill Road. No contact with the victim, Wilfredo.
I'm sorry. Someone's microphone is giving feedback.
Yeah, but no one's messing with their microphone. I heard that too. So hopefully it stops. We may be in one of those sticky situations. All right, keep going. So it was no contact with the victim.
Anger management course within 6 months.
Okay.
And 150 hours of community service.
Got it. Thank you.
You understand that?
Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge, which is 20 years?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you are expecting today, that you have the right to withdraw your plea of guilty?
Yes.
Are you on probation or parole anywhere?
No.
Do you understand that if placed on probation, you cannot violate any criminal laws of any governmental unit?
Yes.
You understand that if when you're on probation, you must follow all the special conditions of your probation?
Yes.
You understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence.
Yes.
You understand that you're not allowed to possess or use a firearm while on probation.
Yes.
Are you a United States citizen?
Yes.
You understand that by pleading guilty to this felony, you may not receive, possess, or transport a firearm.
Yes.
Are you asking to be treated as first offender of the provisions of the First Offender Act?
Yes.
Have you ever pleaded guilty to a felony in the state of Georgia?
No.
Have you ever pled guilty to a felony in any other jurisdiction?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
You understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status can be revoked. This means that you can be adjudicated guilty and you can be resentenced up to the maximum sentence for this charge.
Yes.
You understand that by entering a guilty plea today, you're waiving any and all defenses, including any mental health defenses.
Yes.
You understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at trial.
Yes.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Ms. Frederick, how do you plead to the charge of aggravated assault in indictment number 24 SC 003925?
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charge against you?
Yes.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
And do you understand that for a felony charge, you only have 4 years from today to file that petition?
Yes.
Judge, if this case was to proceed at trial, the state would prove that on June 21st of 2022, officers were dispatched to 5405 West Hill Road in reference to an assault call. Upon their arrival, they observed Ms. Frederick crouching in the woods. They made entrance into the residence where they were met with a female witness by the name of Ms. Bailey, who stated that the victim was lying in the kitchen, whom they found bleeding from a wound slightly underneath his left chest. There was another witness there that was applying pressure to Mr. Muniz's wound. Mr. Muniz stated that he was stabbed by a Black female, but was not able to give any further details at that time. The officers did speak with Ms. Bailey, one of the witnesses, who was a friend of the victim, who stated that Ms. Frederick was inside cooking and Mr. Muniz came in there. They had a conversation over possible infidelity. And Ms. Bailey stated that Ms. Frederick then stabbed Mr. Muniz with a kitchen knife. And then she did flee the scene right after. There was an additional witness, Mr. McCurry, who was also in the residence, who stated he did not see the defendant stab the victim, but he did see her put the knife in her purse before fleeing the scene. And all of this did occur in Fulton County, Georgia.
All right. Thank you. Look one thing up. All right. Ms. Jackson, do you have any criminal history information on Ms. Frederick?
She has 4 cycles. The last arrest was August the 4th, 2018 out of Clayton County for battery, family violence, and cruelty to children in the 3rd degree. Those charges were non-pros on December the 5th, 2018. She does have 1 misdemeanor conviction. It's in 2011 out of Henry County for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Thank you. Ms. Rios.
Yes, Your Honor. Ms. Frederick is 34 years old. She works at Pure Beauty Bar as a hairdresser. She's been doing that over 10 years. She has 1 child, a 1-year-old daughter.
She did graduate from high school and she's from the Atlanta area. There's a little background about what happened. She was at a family cookout with her boyfriend. He came aggressively to her, accusing her of cheating. She said he has a gun, always carries a gun, and started to pull out the gun because he was very angry. And she was cooking, had the knife in her hand, and reacted because she was scared at the moment. So this could have been more of a self-defense situation, but she understands that anything could happen at trial, so she wanted to take a plea today. I'm asking for, well, the negotiated plea is 10 years, but I am asking for a behavioral incident date, so it would be a little less, maybe 3 years after, if she's doing everything good to be removed from probation, and for her to take it under first offender.
Okay. I forgot to ask Ms. Dilligard, has your office had any success contacting Mr. Munoz?
We had partial success, but nothing substantive. We've been able to get a good phone number and reach out multiple times, but we haven't been able to connect.
Okay, got it. Ms. Frederick, anything you want to add?
I just want to say, I understand why he doesn't want to present himself to speak on his behalf of what happened. And I just, in my position, it was just a self-defense situation. If not for the loud crowd of his family members there, I wouldn't have probably left the scene at all, but it was more going on.
Your concern was he was going to shoot you?
Yes, him and also the people who spoke in the report and others that was there.
Okay, those folks, the witness names that I heard were his friends or family members?
Yes, one of them was a female who was also aggressive with me.
Okay, did you have friends or family members there?
No, it was just me there.
That address, the West Hill Road, is that, whose place is that?
The guy that got hurt.
Mr. Munoz's?
Yes.
Okay, that was his house?
Yes.
Okay, and you were over there?
We were having a barbecue, but it was mostly his friends and family there.
Okay. And you referred to him, that guy, his house. You were described as having been in a relationship with him at some point. Were the two of you in a relationship?
Yes.
Okay. At the time, this was a few years ago.
At the time we were.
You were still.
It ended, I guess, that night.
Okay. Did you get arrested at the scene?
Yes. And the only reason why I didn't speak or have anything to say, because he was already hurt. I felt like he was already dealing with consequences, and so was I.
Any sense of how severe his injuries were?
I believe I'm not sure, but.
You haven't had any contact with him since then?
We have shortly after. I know he went to the hospital. I'm not sure what all happened at the hospital. I know he was back to work immediately after.
Okay, so the contact you had with him immediately after, it wasn't, I was in the ICU for 6 months.
No.
What kind of?
I think I was 2 days. By the time I was released on bail, he was also back home.
Okay, and doing whatever his job is?
Yes.
Which is what, or was it?
Driving trucks.
Okay, all right. And you have a 1-year-old boy or girl?
A girl.
What's her name?
Kalia.
Okay. Do you live anywhere? I don't know where West Hill Road is in Atlanta.
No, I'm not around.
Okay. Any questions about anything?
No.
Sorry, did you say West? It's West Teal? Did you say Teal?
What I was trying to say was West Hill Road. Is that not what it is?
It's West Teal.
How do you spell it?
Teal.
Like the color?
Yes.
West Teal Road. Okay. That road, did you live anywhere near that road?
At the time, I currently was there.
No, right, but now you
No.
don't live anywhere. Just in case Mr. Munoz still lives at West Teal Road.
No, I'm not around this area.
Okay, all right, good.
No.
Then, Ms. Frederick, I find there's a factual basis for your plea. That your plea is knowing and voluntary. I'm sentencing you pursuant to the Probation Options Management Act. All that means is that while you're on probation, if there is a little bump in the road, you and probation will figure out how to address that. But if it is something more significant, you get arrested for anything, or there's any evidence that the state gathers that you were having contact with Mr. Munoz, that comes back to me and we'll work through what to do about that. You are asking for first offender. You qualify for it. I need to make sure you understand the risk of first offender. The benefit is, if I sentence you as a first offender, when you leave here today, you don't have a conviction. So if your employer says, hey, it's time to re-up, you got to fill out these forms, and there's something on there that says, are you a convicted felon? The answer is you are not. And as long as you do well on probation, you remain not a convicted felon. The risk of first offender is that anytime during your sentence, if there is a big mess up, you get into a disagreement with whoever the new significant person is in your life, and you get arrested for something, that could be a reason for me to revoke your first offender status. So you'd have your new charges, but I could, after a hearing, you'd have a lawyer there say, you know, you misled us. This was a self-defense. It's not you. It's not the real you. Here you are stabbing someone else. And I could, because aggravated assault is 1 to 20, I could say, you know what, I'm going to resentence you as a convicted felon and sentence you to 5 years on this old Munoz thing because of the new thing. Yeah. So I need to make sure you understand the risk of first offender along with the benefit. Do you feel like you do?
Yes.
Understanding the good and the risky, do you want to be sentenced as a first offender?
Yes.
Do you have a firearms license?
No.
Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, sir.
Ms. Dilligard?
Yes, Judge.
And Ms. Frederick, is it okay if someone signs for you indicating your guilty plea?
Yes, sir.
All right, we'll do that. I'm going to sentence you to 10 years probation. Special condition number 1 is stay away from West Teal Road. You remember where that is?
Yeah.
Is that a part of town you ever need to be in?
No.
Okay. Number 2, more important, no contact with Mr. Munoz. It's kind of easy to contact people these days. If you show up on his Instagram feed and he wants to make that trouble for you, that's going to be trouble for you. So just don't be following him electronically or through social media either. You'll need to complete an anger management course and 150 hours of community service. That's a lot of hours, so I encourage you to be creative in how you do them. If you have ways you could give back to the community, that's not just picking up trash somewhere, talk with your probation officer, and there are lots of ways you can do it that would be helpful. I will also set a behavioral incentive date of January 10th of 2028. That's 3 years from now. If you've done your community service, knocked out your anger management course, and have had no significant issues on probation, then they can petition me to close everything out early, because you will be 37 and doing all the right things, and why would we be bothering you? Okay. Any questions about that?
With the probation, I would have to pay this fee for the whole entire time I'm on probation?
So as long as you are being supervised, you pay a supervision fee. Okay. If it shifts to unsupervised, Ms. Simpson, then is there no more monthly payment, or it's a lower monthly payment?
She would be, if she hasn't paid off all of her fees, then she would be just paying off the fees that she didn't pay when she was on active probation. But when she goes on unsupervised probation, there aren't any fees.
Got it. So as long as you're being supervised, you're paying that monthly fee. Supervision drops off if things have been going well. Why would we supervise you if you're doing everything you need to do? I don't know where that falls in the 3-year window, but let's pretend that you don't meet your behavioral incentive date because there's a hiccup along the way. At some point, it would become unsupervised. You don't pay any supervision fees when you're not being supervised.
Okay, and that's the only fee I have?
I can't speak to that. I think there are other fees that flow with a felony conviction, but the one that would be recurring over time is the supervision fee.
Okay.
All right. Any other questions?
No.
Okay. Then we're done. You are going to need to report to probation, and I'm directing you to do that. We're going to wrap up now, but you're going to talk with Ms. Simpson, who's in green, and she's going to give you reporting instructions. Do you live in Fulton County?
No, I'm in Clayton County.
Okay. She's going to tell you where in Clayton County you need to go on a certain date and time. You're going to leave with a piece of paper. Don't miss that first date. Okay.
Okay.
All right. Thank you, everyone. Ms. Jackson, we still have a few pleas, is that correct? Okay, we're gonna resume Ms. Jackson at 1:30, so I will see you then. Mr. Jasper, anyone who's on the Zoom, you are free to drop off and be at ease We need to break for the staff. I have to go to a meeting and we're gonna pick back up at 1:30. 1:30.
Excuse me, you said I got to drop off, Jasper?
So Mr. Jasper, you can stay on if you want, but the screen is about to say, we'll see everyone at 1:30. So I'm not making you stay on between now and 1:30, but you need to be back on at 1:30, okay?
Okay then, okay.
Thank you.
Just leave the little packets for everybody that is left, and I will take care of it.
I got to drop off, come back at 1:30.
Yeah.
Any event, everything comes the way I want it to get mine. I don't want to have to deal with nothing else. If something is in her phone, I'll give her an opportunity, like a phone. So you just move forward. Okay. At the end of the day, if the kid's my mind, there's no reason to look for it. So yo, hello? Yeah. Yeah, hey, yo, I got the court. They say they going back. They coming back on Zoom at 12:30. They be coming. They be right on exact time 12:30.
Yeah, when tomorrow is it?
No, today at 12:30.
12:30 is 1:26.
I mean not 12:30. I mean 1:30. I got to
You
be
gotta go back to what you just said.
at 12:30 at 1:30, right?
Yeah. 1:30, yeah.
Yeah, okay. I know. I just tried to get there. They didn't send Zoom. They ain't saying that. Hey, yo, I'm gonna take 3 years probation.
Oh, okay.
But I gotta take that shit. I ain't want to take that shit in New York. But New York be the best place I take it at though.
Oh,
But they don't be sweating them out. They don't sweat a motherfucker in New York.
Yeah.
Damn, that shit fucked me
I
up.
just want to let you know your conversation is on speaker. You need to mute.
It's crazy.
Hello, who this?
Huh?
Hold on. Who this? Hello? Hold on for a minute.
Somebody was saying, hello?
Yeah.
Somebody was saying, come see on speak. So I gotta go back exactly 1:30, right?
Yeah.
They'll come back home, cause a lot of times get it, so we can go. All right, baby. I said, I'm gonna take the probation.
Okay.
Yeah, I got to pay $150 to get that shit transferred from New York. You know what I'm saying? All right, I'm gonna talk to them. I'm gonna get back on them now because I'm 129, all right? All right, see you later.
All right, unmuted. Looks like Ms. Wood is available virtually. Is she the only one with cases left, or did Ms. Rios have some?
I think I'm the only one, Judge.
Okay, well, great. And we've got a quorum because we've got Ms. Rivers, we've got Ms. Nix, and we've got you. Let's just make sure we're being thorough. One second. There's a lot of paperwork for that one guy. So did we do Mr. Woods's plea, or that's one of yours that's left?
That is one of mine that's left, Judge, and I'm just having some video issues, so I will be on just a second.
Okay. And then I know we've got Mr. Jasper. He's on and has been pretty chatty. So I'm just looking for. Fine. Okay.
Your Honor.
Hey, Officer Evans.
Hey, I just wanted to let you know I am tuned in virtually right now. However, I did receive one of the warrants back for Mr. Wright.
Good.
From Judge Carncel, and we're just working on the one from Judge Dunaway, trying to get that over. And
Great.
I'll let you know as soon as that happens.
Okay. So I think
Okay,
all we have. Yes?
Oh no, I'm sorry.
That's it?
Oh,
Okay.
yes, thank you.
So Ms. Honholt never made it here, I think. Did we confirm, Ms. Wood or Ms. Nelson, that Ms. Honholt's in state custody?
Judge, she is in state custody until 2031.
Oh, all right. Maybe we can connect her virtually someday and sort that one out.
I think we've been trying to do that for a while now.
Okay. I don't think we, Team McBurney, knew she was in state custody. Maybe that was it. I don't know. Maybe I knew she'd been in Cherokee. She's bounced back and forth. We'll figure it out. So then it's just Mr. Jasper and Mr. Woods. So Ms. Wood, I will let you tell us the order in which we're going.
I don't see Mr. Woods. I'm hoping he's on the iPhone, but I know Mr. Jasper is super eager to go, Judge, so.
Okay, and I see Mr. Woods. He's there. He was iPhone before, but let's do Mr. Jasper first. So Mr. Woods, I'm gonna mute you. We'll get you unmuted in a minute, but we're gonna do Mr. Jasper's plea first. So Mr. Jasper, if you could unmute, that would be great. And let me guess, Judge Edwards is too busy to talk to you.
Yes, I'm right here.
Yes, Your Honor. Judge Edwards is at out to lunch until after 1400, and Judge Brooks is got a hearing. I was having to walk by, I saw your light was on.
Okay, I'm happy to help. I gotta, if you're good, I gotta knock out these pleas and then we'll do, what do you have?
Just the presiding matter, Your Honor, pen order.
Okay, easy to do. In fact, if you get that to Deputy Gordon, I can have it warm and ready by the time we're done here.
Yes, Your Honor. Thank you, Your Honor.
You're welcome. Thank you. Okay, Ms. Rivers, good afternoon. Are you ready to do some takedown?
Yes, I am, Judge. Good afternoon.
Great, then we are gonna go live with position 14. It's 24 SC 003973, State versus Jasper. Mr. Jasper is appearing virtually, and let me get him on the screen here, and we can remove that one. His attorney, Ms. Wood, is appearing virtually. There she is. So we've got everyone we need. Mr. Jasper, in a moment, Ms. Nix is going to put you under oath. I got to ask you a couple questions first, and then we'll get rolling, okay?
Okay.
First question, you have a right to be here in open court in this big public space, but you can waive that right and appear virtually from the land of purple ceilings. Is that what you want to do?
Yes.
Okay, then you're going to appear from there. You also have a right to have Ms. Wood by your side so that you could ask her questions and just know my lawyer's right next to me. Virtually, she's right next to you on the screen, but she is in a place with blurry walls, unlike your purple walls. And I need to make sure that's okay by you.
Yes, it's okay.
All right, if you ever need to speak with her privately, let me know, and we'll move the two of you into a breakout room so you can do that, okay?
Okay, then.
Excellent. Ms. Nix, when you're ready.
Thank you, Judge. Mr. Jasper, please raise your right hand.
Yes.
Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
My name is Phineas Jasper, Phineas. Last name Jasper, Jasper.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol? Is there a medication that you normally take that you have not taken or been given today?
No, I take insulin. I'm a diabetic. I take insulin. I take insulin. I take
Does that affect your ability to understand these proceedings?
Oh, no. It's not going to affect my ability, no.
Okay. How old are you?
I'm 66.
How far have you gone in school?
I went to high school. I went to 12th grade, but I have a GED though.
Is English your native or dominant language?
Yeah, English, yes.
Do you understand that you've been charged with the following offenses? Counts 1 through 3 are attempted theft by taking, and count 4, identity theft.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, I understand.
Have you had the opportunity to review your rights with your attorney?
Yes.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the case with your lawyer, Ms. Wood?
Yes.
Are you satisfied?
Well, hold on. The question was, do you need more time to talk with your lawyer?
No, I don't need more time, no.
Okay.
Are you satisfied with her services?
Yes.
Ms. Wood, do you waive a formal reading of the indictment for purposes of the plea?
We do.
And do you waive any null defects in the indictment for purposes of the plea?
So waived.
Mr. Jasper, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? As to each count, the state recommends 3 years to be served on probation to each count to run concurrently with each other. Special conditions are stay away from all Regions banks, have no contact with the victim, Gary Holton, that's GaryHolton. You must maintain full employment or be a full-time student and complete 100 hours of community service.
100-hour community service? Yes, I understand.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, I understand.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Do you understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively?
Yes, I understand.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, I understand.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, I understand.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes. Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
Do you understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes, I understand.
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Would you repeat that, please?
Do you understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes, I understand.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of 3 counts of attempted theft by taking and identity theft in indictment number 24 SC 003973?
I plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that since these are felonies, you have only 4 years from today to do so?
Yes.
Judge, had this case gone to trial, the state would expect the evidence to show that on or about November 21st of 2023, the defendant did attempt to withdraw funds from a bank account at the Regions Bank, and 3 times in the amount of totaling $12,540. One was $2,020. One was $8,500, and a third was $2,020. Those were all from the account of Gary Holton. Mr. Jasper produced identifying documents of purporting that he was Gary Holton, including a fraudulent social security number and driver's license, to the banks in order to withdraw these funds. The bank contacted law enforcement, and law enforcement determined that Mr. Jasper was not Gary Holton, as the real Gary Holton is a white male in cognitive decline that requires 24-hour care and lives in New York. And Mr. Jasper was identified by his suspended Alabama driver's license. And that occurred in Fulton County. The defendant does have 4 prior felonies, 2 from the 80s and 2 from the 90s. And they're all in New York.
And Mr. Holton was from New York.
Yes.
All right, thank you. Ms. Jackson, good afternoon. Can you share the criminal history information you have for Mr. Jasper?
Yes, Your Honor. He has a total of 18 cycles. The last arrest was November the 2nd, 1997, out of New York for criminal possession of a weapon in the 2nd degree and burglary and reckless endangerment in the 1st degree. He does have prior felony convictions. It's one in 1998 out of New York for criminal possession of a loaded firearm in the 3rd degree. It's an additional one in 1998 out of New York for criminal possession of a weapon in the 3rd degree. It's one in 1981 out of New York for robbery in the 2nd degree and possession of controlled substance. Nothing in addition, Your Honor.
Thank you so much. Ms. Wood.
Thank you, Judge. All I would like to add is that Mr. Jasper wanted me to share with the court, as you've heard, that it's been a really long time since he's been in trouble. And so I'm hoping that this is just a one-off for him. Judge, he has shared with me also that he is receiving disability benefits. So if we could make sure that probation fees are waived, that would be great. And then the only other issue that I think we might have is he lives out of state, and I cannot remember, I hope probation can help me. I can't remember if he has to come to Atlanta and get enrolled and then pay the fee or how that works. But we would ask that you accept the state's recommendation on this case.
Okay, and we'll hear from Officer Evans in a minute about that. Mr. Jasper, in what state do you live now?
I live in New York.
In New York. Well, what were you doing down in Fulton County in November of 2023?
I was down there visiting my niece. I got family down there. I got family living in Alabama, and I have family living in Atlanta, Georgia.
Okay. Well, this doesn't sound like it was an accident. Tell me what happened around Thanksgiving 2023. Tell me what was going on.
To be honest with you, Your Honor, I try to be slick, though, try to get some extra money when I came to Atlanta. That's all I was trying to do. You know, I got caught. So I'm willing to pay the price, pay for my mistake that I made.
Okay.
I came down there to visit my niece and all that.
So you had a legitimate good reason to be down here, but you also were going to be a little slick, to use your word, while you were down here.
Yeah, I was trying to be a little slick. I'll be honest with you. I was trying to be a little slick. I got caught though, you know.
Yeah, it wasn't so slick in the end. Okay.
Nah, it wasn't slick at all.
Ms. Nix, it sounds like no money got to Mr. Jasper, so there's no restitution. Mr. Holton, who may have felt, if he were able to perceive it, that his privacy rights were violated, there's no financial loss to either Regions Bank or to Mr. Holton.
That is correct, as to my understanding.
Okay, got it. Mr. Jasper, anything else well, I got a couple more questions for you. Ms. Wood said that you get benefits, SSDI?
Yes.
Okay, and you are actively getting those benefits now, or you hope to get them in a few months?
Yes, I get them now. I still get them because, you know, my wife died of COVID.
Okay.
My daughter died.
I'm sorry to hear that.
Yeah, my mother just died in October. You know, but you know, I don't know.
Okay, I'm sorry for all those losses. Do you work as well, or are you not able to work?
No, I'm not able to work, but every now and then I do a little freelance stuff. I do what I do is I do facilitate for probation. I used to do it. I ain't did it like in a couple of years, but I do that. Then sometime I do I'm a plumber by trade, so I do that sometime. But other than that, I don't really do no work at all. Cause diabetes got me messed up. My toes and legs is numb.
Okay, I'm sorry to hear that part. I'm curious though. You said something about you facilitate probation. What does that mean?
No, I was doing facilitating. I was like trying to tell you stop the youth from trying to live the life I was living. I was telling them.
Got it.
Trying to facilitate.
Yep.
That's what I was doing.
Got it. You're sort of a counselor and like, look, here's some bad
Yes.
decisions you could make. Look what it did to me. I spent some time in Rikers or wherever you ended up. And people
Yes.
could avoid that. Okay.
Yes.
Appreciate you doing that. Okay. Well, I've heard answers to my questions. Anything you want to add?
And I just want to just add, you know, I mean, I try to get slick when I went to Atlanta, but I've been home for going on 9 years now. No, I just try to do something, but I got caught. Other than that, I just been just cooling out, chilling out, just get my benefits and work every now and then. That's all I've been doing since I've been home. I've been home 9 years since I came home.
All right. Well, I find there's a factual basis for your plea and that your plea is knowing and voluntary. We've answered your questions. You've understood what everyone here has been saying.
Yes.
And I will follow the joint recommendation, which is to sentence you to 3 years of probation for each of the 4 counts, but run those concurrently, meaning at the same time. So the total sentence is 3 years probation. Special condition of probation number 1 is you leave Mr. Holton alone. It sounds like he's a stranger to you, but stop using his name or his ID or anything like that.
No,
Number 2, you need to stay out of Regions Bank. That should be pretty easy. I don't think they necessarily have a lot of branches up in New York, but if you're going to do banking business for yourself or anyone else legitimately, don't do that in Regions Bank.
Okay.
If you cannot document for probation that you're getting these benefits, then you are going to need to pay the probation supervision fee. But if you can document, look, here's my SSDI check or whatever it looks like, you provide that documentation, then I will waive your supervision fees and I will also waive the work requirement. So if you are able to do a little work on the side, like you said, more power to you. But if you show them that you're receiving disability benefits, then I will not require you to work while you're on probation. But I am going to require that you do the 100 hours of community service. And that can be the kind of thing you just described, that kind of probation facilitation, where you wouldn't get paid for it because you're doing it voluntarily because it's community service. But that's valuable, and that's the kind of thing that gives back to the community. And that's something I think you ought to devote yourself to for part of the time that you are on probation. Ms. Nix, anything else from the state?
No, sir.
Ms. Wood, anything from the defense?
No, Your Honor, thank you.
Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Nix?
Yes, sir.
Mr. Jasper, since you're way up in New York, is it okay if someone in my office electronically signs the indictment indicating your guilty plea?
Yes.
Great. Then I'm done, but you're not done. We need to hear from Officer Evans about how this is going to work with you being in New York and the rest of us down here in Georgia and probation and all that.
Yes, Your Honor. We have we have a 7-day window. However, we have to get the information in within 3 business days. I will send over that request of information to Ms. Wood so that she'll have a list of the information that I'll be needing from Mr. Jasper. Okay. And that's all I really need right now. But I will be requesting the police report, and I will get the disposition and the indictment from Ms. Nelson. And Mr. Jasper, you need to have a $100 money order ready when we give you let me give you this number as well. One moment, because you're going to contact the DCS business office.
Yes.
On January 13th.
Okay.
2025. And that number is 404.
404. For what?
404-463.
463.
0410.
04. What else? 40?
0410.
10. All right.
And may I have your telephone number, Mr. Jasper?
My telephone number is 404-338-7714.
Why do you have a 404 telephone number?
Because it's my cousin, it's my little niece. She let me hold the phone when I was down in Georgia. But I have 2 numbers though. Can I give you the other number?
Yes, please.
All right, 347-631-5696.
Thank you. Make sure you call that number January 13th, okay? And
Okay.
Ms. Wood, I'll send that email over to you so you'll have a list of what I need in order to get the process going.
Thank you.
Yes, ma'am.
All right, Mr. Jasper, good luck. Take care of that diabetes. Stay out of trouble. No more bad checks or withdrawals, all right?
Okay, that's sir.
See ya.
Okay, see you.
Mr. We are not going to be able to do that hearing tomorrow because of the court closure, unless I just don't think there's a way that I think it's Thomas now, could get her client to say, I'm fine with witnesses appearing virtually. And I'd hate to have your people finding a way to get on a camera and then not unreasonably, the defense team says, no, we want to be in the same place as the witnesses.
Yeah, I think for your benefit too, because of the way the evidence is, it'd be much easier to look at it in person.
Okay, so I'm going to try to pull off my motion for new trial hearing in the morning because the guy was going to appear from DOC anyway.
Okay.
That's not you, that's another group of folks. But Ms. Nelson will push an email out to everyone, but she let me know that you had officers or agents or folks saying what's happening. And I know schools are closed, so you can let them know, stand down, and we'll figure out what we can next get. This was a perfect afternoon because it was a big window. So we'll see what we can do.
I think I got a Quintavious Jackson revocation on the 28th. So I've shrank this particular one down. So maybe we can.
Maybe you can fit it. Talk with Ms. Nelson. The sooner we could get it on Ms. Thomas's calendar, the better.
I thought it was Ms. Paul.
Well, it was, but the email she sent, it was Dorothy Paul Thomas. Oh, Thompson started with T. So there was another name on there.
Great.
I thought it was Ms. Paul also, but that's moved to the middle.
All right. Well, I'll thanks, and then I'll be in touch with Ms. Nelson.
Sounds good. All right, Mr. Woods, are you ready?
Yes, sir, I'm ready.
Fantastic. You're the most patient man on the team. Let me get you on here. There you are. If you will just be patient for another 30 seconds to take the Berhalter, if you'll come on up here. So as I understand this one, basically you did one of these triangulations. You had a good number, he dropped it. But by looking at who we talked to a lot, like this is the common number and gotta be him.
2 relatives and 2 close friends.
Associates.
Associates, and of those 4, 3 had this common number.
Right, what are the chances? Yeah. So we'll find out.
Yes, sir. I swear.
All right, you swear from the contents of your affidavit are true and correct to the best of your belief and knowledge?
Yes, I do, Your Honor.
Good, you sign where it's got your name and I've signed everywhere else. You're good to go.
Yeah, excellent.
Take care.
Thank you very much, Your Honor.
Okay, I think this is the last one of the day. 24 SC 003843-01, State versus Woods. Mr. Woods is prepared to enter a plea. It's still an hour earlier than you would have had to be here for your suppression hearing, so we'll go with that. Mr. Woods, before Ms. Nix swears you in and we move forward, are you comfortable appearing virtually rather than being here in court?
Yes, sir.
Okay, and are you waiving your right to have Ms. Wood, your lawyer, right next to you while we do this?
Yes, sir.
Okay, if you do have questions for her, let me know and we'll set you up in a breakout room, okay?
Okay.
All right. Ms. Nix, when you're ready.
Thank you, Judge. Mr. Woods, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yeah.
You can put your hand down. Please state your true, correct, and legal name.
Andravia Shimon Woods.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Did you say no?
Yeah, no, ma'am.
Okay. Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
29.
How far have you gone in school?
Bachelor's degree.
Is English your native or dominant language?
Yes.
Do you understand that you've been charged with the following offenses? Count 1 is fleeing and attempting to elude. Count 2, no insurance. Count 3, reckless driving. And count 4, failure to obey safety zone.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had the opportunity to review your rights with your attorney?
Yes.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the case with your lawyer, Ms. Wood?
No.
Are you satisfied with her services?
Mr. Woods, you there?
Oh, yeah, I say yes.
Okay.
Yes, okay, didn't hear you.
Ms. Wood, do you waive a formal reading of the indictment for purposes of the plea?
We do.
And do you waive any and all defects in the indictment for purposes of the plea?
So waived.
Mr. Woods, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? The state will null pros count 1 and recommend a sentence of 12 months of probation to counts 2, 3, and 4. Those will run consecutive to each other for a total of 3 years of misdemeanor probation. Conditions are 100 hours of community service and no driving unless your license is valid. Do you understand that's the state's recommended sentence?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that since there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences consecutively?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, you have the right to withdraw your plea of guilty?
Yeah.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that while you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you? Sorry, go ahead.
I'll just say yes, ma'am.
Okay, I'm sorry. I thought you were starting to say something else. Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Pleading NOLO.
Yeah, so we're gonna plead NOLO to the no insurance, count 2, and then we can do guilty pleas on count 3 and count 4.
All right. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the charge of no insurance?
NOLO.
And how you plead to the charges of reckless driving and failure to obey safety zone in indictment number 24 SC 003843-01.
Guilty.
Are these guilty pleas and no plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
Do you understand that since these are misdemeanors, you have only 12 months from today to do so?
Yes, ma'am.
Judge, had this case gone to trial, the state would expect the evidence to show that on May 12th, 2023, Mr. Woods was driving and was attempted to be pulled over by APD officer Jimenez. He fled from Officer Jimenez at that time and was able to get away. The next day on May 13th, 2023, Officer Jimenez observed the same vehicle and again attempted to make a traffic stop for the expired registration and no insurance. The vehicle again fled and was driving recklessly and then drove through a construction site. The vehicle got stuck in the mud at the construction site, and Officer Jimenez took Mr. Woods into custody. Mr. Woods did state to Officer Jimenez that he fled from officers the day before because of his invalid or because of not having insurance and his invalid registration. Judge, the defendant in this case does have a first offender from 2017 to theft by shoplifting. That's in Spalding County, but I did not see any other convictions. In this case, there is only body cam, no dash cam. And so because of the year required under the statute for fleeing and attempting to elude, I would much prefer to have a dash cam in order to prove this kind of case before I ask Your Honor to sentence someone to a year in custody. And so that is why I have made the offer to plead to just the 3 traffic offenses and 3 years of probation.
So there was no dash cam in either, I guess Officer Jimenez's car didn't have a dash cam.
Correct. Not all of the APD cars have dash cams.
Everyone's got body cam, but not all the cars have the dash cam.
Yes. So he did have his body cam on, but all you see is just him, the steering wheel of his own car.
Not that I wanted to see the mud. That's what I'm. Okay, got it. Thank you for that. Ms. Jackson, criminal history information for Mr. Woods, please.
He has 2 cycles. The last arrest was September the 15th, 2015 in Spalding County, Georgia, for theft by shoplifting, a misdemeanor. It was actually 3 counts. 2 of those counts were null prost on July the 25th, 2017. He did receive first offender treatment in 2017 out of Spalding County for 1 count of theft by shoplifting, a misdemeanor. That case was sealed July the 26th, 2018. Nothing in addition, Your Honor.
All right, thank you, Ms. Jackson. And Ms. Jackson, I tried sending you something through chat. I don't know if you saw it, but we do not have court tomorrow that you need to be here for. So if that means you get the whole day off, fantastic, but don't worry about dialing into one of our sessions.
Thank you, Your Honor.
All right, I will see you. It'll be a while because next week I think is all civil. So it may be towards the end of January. Be well.
Okay, thank you. You as well.
Bye. Ms. Wood.
Thank you, Judge. Mr. Woods is 29 years old. He is a lifelong Georgia resident. He has a bachelor's from the University of West Georgia. Judge, he's got 2 little girls that both live with him that he takes care of. We had been working with Miss Nix. We had hoped to get this into diversion, but because of that first offender, it was rejected. And so we're hoping that you'll accept the state's recommendation. And I did just want to let the court know the reason the reason we're tendering this under NOLO and the no insurance is because he does want to continue working. And I did not want that no insurance conviction to affect his valid license now. So we would just ask that you accept the state's recommendation in this case.
Got it. Okay. Mr. Woods, what kind of work do you do?
I currently do drive for DoorDash and Lyft.
So a driver's license is important.
Correct.
All right. Do you have a valid license right now?
Yes, sir.
What was wrong with it back in May of 23?
Nothing was wrong. My license always been valid.
Oh, right. It was the
It was the car
registration
registration.
and no insurance.
It was just a no insurance thing at the time.
Okay. Do you have insurance now for your car?
Yes, sir.
What do you drive?
2020 Toyota Corolla.
The people's car. Okay. Your two daughters live with you?
Yes, sir. They're actually in the living room right now at the TV.
Okay. Who else lives in your household besides you and your two daughters, if anyone?
My wife.
Okay. So you've got help. If you're out running a DoorDash run, there's another warm body, a grown up, to help take care of your daughters.
Right.
Okay. Does your wife work outside the home?
Yeah, she's a RBT. She's actually one of her clients right now.
Okay. All right. So your license is good. It's not been the issue. Your insurance is now good. And is the registration valid on your 2020 Corolla?
Yes, sir.
Okay. Talk to me a little bit about getting stuck in the mud. What happened? You just you just started sinking like quicksand?
It was the construction site. I guess they was working on it at the time, and yeah, it was. I want to say it was raining that day, and yeah, it kind of got stuck in like a pile, so it just came to a complete stop.
Okay, and then Officer Jimenez was able to get his guy. Okay, right. Do you have any questions about anything we discussed, Mr. Woods?
Not at all.
All right, well, I find there's a factual basis for your plea, that your plea was knowing and voluntary. I guess you had to spend a couple days in jail, looked like 7 or 8. So next time, don't get taken away from your kids, just pull over and
let the
guy do whatever he's gonna do, and we'll go from there.
It's fine.
Ms. Wood, can someone from my office sign the indictment for you?
Yes, Judge.
Ms. Nix?
Yes, sir.
And Mr. Woods, okay, if someone from my office electronically signs the indictment indicating your no-low plea to count 2, the dismissal of count 1, and your good old guilty plea to counts 3 and 4.
Yes, sir.
All right, I think those are the right number of counts. I was looking at the wrong thing. Yeah, that's good. All right, I will follow the negotiated resolution and sentence you to 12 months probation on each of the 3 counts. I will run those consecutive to each other. That's kind of a lot of misdemeanor probation as things go, but I think that's a good proxy for basically it's kind of fleeing and eluding times 2. You only got charged for one of them. You were successful in the other one. And it reflects that there was this felony sitting there, but the state is dismissing it. I understand why. So it is 3 years of misdemeanor probation, 100 hours of community service. You probably heard me say this to others, but I mean it. Work with probation to figure out a way where you can do those hours in some manner that is meaningful to you and others, rather than sweeping a street or something, because that's a bunch of hours. And then I'll also include as a condition, but it's the law anyway. But his issue wasn't a valid license, so I'm not gonna worry about that.
I just am concerned about the reckless driving, putting enough points on his license to suspend it. I mean, it would be a violation of the law for him to drive anyways.
Right.
It's kind of just a reminder that it's got to be following all traffic laws.
I think he'll remember after this and getting stuck in the mud. So 36 months probation, 100 hours community service. Misdemeanor probation is not administered by Officer Evans and her colleagues. So what's going to happen is that Ms. Wood, your lawyer, is going to either push contact information to you, someone to call or email, or she's going to give them your contact information, and you might get that call or email from misdemeanor probation. If you get something from, what's it called? Justice Solutions. I don't remember what they're called. It's a private company. Don't think it's spam. You need to connect with them, because if you don't, then they send me a warrant, and that's a whole lot of months I have to play with, 36 months. So if a week has gone by and you have heard nothing from these probation people, you ought to call Ms. Wood to say, I don't want to get sideways with them on day one, and she can help you make the connection, okay?
Okay, sounds good.
All right, Ms. Wood, anything else?
No, Your Honor, thank you.
Ms. Nix?
No, sir.
All right, Mr. Woods, you're good to go. Good luck with things. Take care of your kids.
Okay, thank you. Y'all have a great one.
All right, I think we're done. Productive day. Let me just make sure I didn't miss anything. Since you're both here, even though this will be a Dilligard thing going forward, Ms. Wood, we have put Ms. Hunt, she is on the March trial calendar, and we're preserving her final plea rights. If you know the only thing that's going to resolve her case is trial, then we should leave it as is. But we do the Department of Corrections a big favor if we line up a plea virtually rather than having to produce her. So if you need help, Ms. Wood, lining up a one-on-one with Ms. Honholt, let me know. I've got a great resource with GDC who will make that happen. I don't mean to suggest you can't do that on your own, but if for whatever reason you're getting the runaround, or like, oh, female inmates, it's harder, let me know, and I will make sure they connect you with Ms. Honholt. I don't know what the negotiations are like, but if she's in GDC custody until 31, it sure seems like this is something that could be rolled into that. But that's merely an observation. It's not pressure in any direction. The pressure is, let's avoid, if we can, having to produce her just to show up to say, I plead to 2 years to serve to run concurrent. Okay? So just keep me posted on that. I guess someone will let me know about Derek Harrison. That's someone, oh no, he's taken care of. It is.
Yeah, that's the drug court diversion.
Right.
I think we're
Was
having.
that a plea?
Yes.
Right, that was a plea.
I think with Mr. Harrison, he's not actually in custody on any of our cases. He's in custody on a state court case. And so
get out. That's right. You're exactly right. You may not have gotten here yet when we talked about that, but someone shared
good.
that with me. So I think we're good with everything else. And I will make sure to modify the bonds for the Hammond brothers so they switch parental households. All right, Ms. Wood, you should get an email from Ms. Hansberry soon. I'm gonna call her to see if we can manage to keep the motion for new trial for Tobias Johnson. Was that a case in front of Judge Emerson?
Yes, Judge.
Good, because I feel real sheepish, like I don't know anything about this case, and a sign of my old age if I don't remember it, but it doesn't ring any bells. So you know it because you tried it. It was in front of Judge Emerson. And so we'll get something out to the appellate attorney and you, and I'm assuming it's Ms. Eaglin who's got it for the state. And ideally, we can still do that tomorrow.
Okay.
All right. Let me see if there's anything else on the calendar. That is it. Next week, I'm around. Should you have any pleas or business, it's civil stuff I'm doing the week after I'm at the judges conference, and then we're back to it. Officer Evans?
Yes, Your Honor. I just wanted to let you know that warrant 25-00136 PV for Mr. Wright is in place.
Excellent.
So we have at least one of the warrants in place, and we're still working on the warrant for Judge Dunaway.
Okay. So then Ms. Nelson and I can move forward with his final disposition.
Yes, Your Honor.
Because there's now a warrant there. Okay, thank you so much.
Judge.
Yes, Your Honor.
Judge, I did want to let you know, we do have a small jail Zoom calendar on the 17th. If your civil trial is completed.
Oh, it will be. All the civil stuff is collapsing. They're either not ready or they settle. So great. So Friday afternoon, we'll get to see someone. So we'll do that. Thank you for reminding everyone.
Has that calendar been published, Ms. Nelson?
I thought it had been. I'll double check, but if not, it's still gonna probably go out, but I'll see.
Okay.
Yeah, there's not anything attached to anything I have, so.
Well, that's because it's civil, and I need to talk with Monica if she's gonna set the Zoom up or if I was.
Got it. Okay.
But I'll double check.
Okay, my guess is that by the 17th, there will be no civil Zoom left, so you'll get to do that, but you can talk about, we'll know a whole lot more Monday morning, but I just don't see anything that's gonna push through the whole week.
Okay, thank you.